for the inauguration ceremony of the International Advanced Training Course on Intellectual Property, which is being organized by Comstech in collaboration with Comstech Inter-Islamic Network on Science and Technology Parks situated in Islamic Republic of Iran. We are most grateful to Dr. Mahmoud Sabri Motlaq, Executive Director, Ms. Noor Rizq, International Relations of INSTP, and Comstech staff for all their help and cooperation for the success of this event. We are now going to begin with recitation from Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الرحمن علم القرآن خلق الإنسان علمه البيان الشمس والقمر بحسبان والنجم والشجر يسجدان والسماء رفعها ووضع الميزان ألا تطغوا في الميزان وأقيموا الوزن بالقسط ولا تخسروا الميزان صدق الله العظيم.
Ladies and gentlemen, the purpose of this course is to enhance knowledge and the ability of IP experts of Islamic science and technology parks in the field of intellectual property management. It covers introduction to IP management, patent portfolio generation and management, fundamental principles of IP administration, patent law, trademark law, and IP management. I would like to request His Excellency Professor Muhammad Iqbal Chaudhry, Coordinator General Comstech, for his welcome address. Please welcome.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. Assalamu alaikum wa rahmatullahi wa barakatuh. Excellency, dear brother, Mr. Muhammad Sayyid Muhammad Ali Hussaini, Ambassador of Islamic Republic of Iran, my dear colleague, Professor Dr. Muhammad Ali Mehsa, one of the most important members of the Comstech team, resource person from both home and abroad, distinguished colleagues, excellencies, ladies and gentlemen. Very, very pleased to have ambassadors of Yemen, Sudan, and representatives of other countries, and members of the Comstech Consortium of Excellence. So we have a whole range of different guests, and this event is attended by a very large number of participants, both online and in person. Now, this is the event which is jointly organized by the comstech, which is OIC Standing Committee for Science and Technology, premier organization in the OIC system, as well as INSTP, which is Inter-Islamic Network for Science and Technology Park, based in Iran. And we have this great pleasure of working with them closely on various projects of the interest of the Muslim Ummah. This advanced course is in fact continuation of the earlier interaction which we had with INSTP. INSTP has conducted a very nice webinar through which they were able to introduce with the various aspects of intellectual property right. And based on that it was decided that we would have an in-person event, and here we are in Islamabad. But this is not the end. We have a greater plan. We plan to work with INSTP on many regional events, which we intend to organize in Francophone Africa, Arabic-speaking Muslim countries, as well as Anglophones. INSTP is one of the 13 networks of comstech, working on a very important aspect of science, technology, and innovation. And that is the reason why we place INSTP at a very high esteem. Iran hosts three very important networks, Excellency. These three networks are among the most important networks because that deals with nanotechnology. There is an inter-Islamic network on nanotechnology. There is an inter-Islamic network on virtual education, virtual universities and open universities. And of course, inter-Islamic network on science and technology parks. So all three are extremely important and we are very proud to work with them. These are comstech networks which were established by the Comstech General Assembly. And we are very pleased that the government of Islamic Republic of Iran is very generously supporting all three networks. And thus, these networks are playing extremely important role in the socio-economic development of the Muslim world through the application of science and technology. See, the current course is very important because this addresses this addresses a very important aspect of intellectual property right. Intellectual property right in the context of science and technology is in fact science of today which convert into technology, and technology has to be converted into sellable products, services. In fact, that is the strength of the universities and research and development institutions of the Muslim world, that we have very large number of very high quality institutions. But there is a failure at the end because we are not able to protect these intellectual property rights. And that is where we all need to strengthen the capacity at different levels. So what we intend to do, that we intend to have 3 levels of training in collaboration with many institutions within the OIC system and outside OIC system. The first is extremely important at a policy level. You would be surprised to know that out of 57 Muslim countries spread over 4 continents, many of these Muslim countries do not really have their own national intellectual property right policies. As a result, it becomes very, very difficult for them to benefit from intellectual property right regime. So our first challenge is to train these civil servants, representatives of ministries of industries, commerce, judiciary, and others, so they can develop their own, formulate their own intellectual national policies, intellectual property right policies. This is one level, and for that we are working closely with a very, very important organization in Republic of Russia. As you know that Russia is an observer state of OIC system, and we work closely with many observer states, including Russia and China. And Russia has actually given us very important support in terms of patent training. And so for the first civil servant training will be held in Kazan and Moscow early next year, and that is going to be focused on developing your own national policy for intellectual property right protection. The second level, ladies and gentlemen, is the technical level. When you file an application, there is a need of a technical competency in intellectual property right offices, patent offices, that they should be able to analyze the content of the patent. It's called patent analytics. They should be able to see what are the content, whether they are, they fit with the novelty criteria, they are not prior art, they have some kind of usability. So this technical competency is extremely important, and so that we are working very closely with the Ross Patent, which is the largest organization in the world, with the Russian Federation of Russian Intellectual Property Right Agency, to develop this capacity industrial analytics in the OIC countries, and for that many events are actually planned. But at the grassroots level, when we talk about R&D workers, faculty members, they need to understand what are the contours of a new development, what is the innovation, and how to protect innovation in terms of packaging a good patent application, so they can be able to get IPR protection on their innovation. That is something at a ground level, and that is a very, very important aspect. For that, we had a very good discussion with Sister Fatima and Mitra, and both of them have actually agreed that we will be able to conduct such events in different regions, including Francophone Africa, Central MENA region, Middle East and North Africa region, Central America, Central Asia, as well as Southeast Asia. So we'll be able to have these events organized in next 1.5 years to build the capacity of the people who generate knowledge which can be transferred into technology. So at different levels, we are planning to work together with our partners to develop this intellectual property right capacity. Now, why it is important? It is important because of many reasons. At the micro level, I'm academics by heart and by training. And if I develop something, I would really like it to be protected. But I do not really have either skill or ways and means to protect it. Now, skill is very, very important, because if you want to go to file a patent, you need to understand what are the major components of a patent application. That is a skill which we need to develop. Ways and means, if you want to patent something at European Union or in USA, it's going to cost you about $15,000 to $20,000. Who have this money? Literally, this is something which is beyond the ways and means of any individual. For that, it is extremely important that national innovation system, patent support system has to be developed. And for that, we need to work closely with the national government. Very, very important. If intellectual property right is protected, then you would have possibility of benefiting for your time and the efforts which you have placed in developing that innovation, to benefit in terms of money, in terms of reward. So it encourages you to go for further innovation. That is the important component of ecosystem, innovation ecosystem. At the macroeconomic level, the nations which are capable of developing their own intellectual property right and able to protect them, enforcing them, are now among the most developed countries of the world. So it is the backbone of intellectual knowledge economy and intellectual innovation system. And that is extremely important, that we should really work on intellectual property right. I want to give you an example of how countries which were capable of protecting their intellectual property were able to gain out of this very important practice. And this is the statistics which I obtained from the WIPO website. IPR is the big backbone of global trade and businesses. For example, in 2020 alone, in 1 year, developing countries, including least developed, low developed, and middle income countries together have paid $340 billion for royalties, nothing but royalties. $340 billion. Remember, national economies are sinking for a few billions. There are economic meltdown in many countries, and this is a huge sum of money which we all are paying for royalties of intellectual property which somebody else has protected. Not, they don't have any material support, they don't do anything. The only thing which they do, they allow their intellectual property right to be used for the production of certain goods and services. So $340 billion. There is the kind of intellectual property right. The cost, the price tag of intellectual property right now is $340 billion 2 years ago. It probably have increased, but in return of it, what we get, very little amount of money. And most of the intellectual property right which we generate in our institutions, in our R&D organization, is either wasted or pirated. And that is a global fact today, that many of the patents internationally protected by large industrial conglomerate or enterprises in the West are pirated. And that is the reason why it is important for us to protect our intellectual property right, and also to develop capacity to enforce IPR laws, both nationally and internationally. In this context, Comtech is working closely with many organizations. I mentioned about the Republic of Tatarstan, I mentioned about Russian Federation Patent Office, and I mentioned about our own network, INSTP, based in Iran. And we intend to do these because we understand that whatever we are doing in order to develop the landscape of science and technology in the Muslim world, it is important that end result of it, it is the outcome of very hard work that has to be protected also. So there are many activities which we intend to do, and we are very pleased that we are focusing our efforts largely on countries of need. LDC Africa is the focus of many of our activities. Now, at the end, I would like to very briefly tell you about Comstech and its initiatives. Comstech, as you know, is a standing committee for science and technology. It was established in 1981, and we're very proud to have all 57 OIC member states are the members of Comstech. Iran is certainly a very, very active member, and we benefit both from the excellence of Iran as well as political will which we receive at political support, which we receive at the highest level. Now, Comstech is able to initiate programs such as the largest research fellowship program in the OIC system. So we have over 1,000 fellowships of different types. We have 500 fellowship program with Palestinian students. We have country-specific program. I'm very proud to have Excellency, my dear brother, the Ambassador of Yemen. There is a specific program for Yemen. We are launching a similar program with Nigeria. We have proposed a program with Sudan as well, sir. And we will be launching these programs with Burkina Faso and Ivory Coast. So these are binational programs, bilateral programs in which we would be addressing the country-specific needs for these nations. So we'll be able to contribute meaningfully in areas of relevance. We have launched a very interesting program called comstech-oic Science in Exile program. Science in Exile program is largely for the scientists who are displaced because of internal conflict, regional conflict, and other civil wars, and they are present as refugees in other countries. So what we have done was that we have launched this program with the World Academy of Sciences and UNESCO, and this Science in Exile program is provide them opportunity of of these scientists being placed in host institutions, so they continue to perform their science. And when they go back to their countries, they are uh, capable of contributing in terms of science and technology development. We have a program with International Center for Genetic Engineering and Biotechnology, which is a premier organization, ICGEB, and that is centered around biotechnology. That is largely for LDC Africa and for Central Asia. We have a very long standing, about 15, 20 years, we have been working with the International Foundation of Science, and that is a large research grant fellowship, research grant support system through which we are supporting the research projects of very large number of young people, especially from LDC countries, small island nations, and sub-Saharan African countries. We also have recently launched a program with the Islamic Organization of Food Security, IFS, and that is centered around the development of agriculture. So there are many specific programs which we have launched. And of course, we have a technology portal. And if you visit comstech website, you'll find it extremely happening place, because there are so many things happening at the comstech platform. And I'm sure that your interaction with those would be beneficial in terms of your participation, as well as the breadth of these activities which we would like to have. We have also launched with Indonesia a virology program. There is an OIC Center of Excellence for Virology and Vaccine Development in Bandung. And that program is critically important because we all understand that virology is important in terms of future diseases, pandemics, and disease burden which we have today. So there are many such programs, and the utility of these programs lies on the effective engagement of institutions and individuals. I'm very, very proud to tell you that comstech is capable, is able to create a wonderful network of top institutions, both within the country and outside. That's called Comstech Consortium of Excellence. Comstech Consortium of Excellence is comprised of the elite academic institutions, and they are the center of these activities. They are there are the places where actual things are actually happening, because without we will not be able to do anything. So Comstech Consortium of Excellence is certainly an important milestone in the development of science and technology in the Muslim world. Today, Comstech is the center of many OIC initiatives. So if you go to Jeddah, you will find that many of the officials of OIC take pride of the achievements of Comstech, and that is because of an excellent team of people which work with us, as well as very close collaboration with embassies, with our institutional partners, as well as our networks. I would like to end by thanking my very dear colleague, Professor Dr. Muhammad Ali Mehsa, and his team for an excellent organization of this event. I'm sure that you would enjoy your stay in Islamabad. Islamabad is currently very green and beautiful, and I'm sure that you would be able to enjoy the beauty of this amazing city. I would like to thank our partner, INSTP, the resource persons who traveled all the way from Iran and other places, as well as the participants who are here. We are the core of the most important learning exercise, and perhaps not the least, Excellency Ambassador of Iran for his patronage. He's a very dear brother, and he's always been very supportive to Comstech activity. Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you, sir. Ladies and gentlemen, intellectual property has an integral part of every business organization. Technology-based companies are built around and founded on intellectual property. IP is an intangible asset which is neither exhausted by consumption nor subject to deterioration, unlike physical assets. I now like to request Honorable Chief Guest, His Excellency Sayyid Muhammad Ali Hussaini, Ambassador of the Islamic Republic of Iran in Islamabad, for his remarks.
Bismillah ar-Rahman ar-Rahim. His Excellency Dr. Professor Muhammad Iqbal Chowdhury, Honorable Coordinator General Comstech, and respected intellectuals, professors, dear ambassadors, ladies and gentlemen, Assalamu alaikum. It's a matter of great pleasure for me to be present in the gathering of the scholars and knowledgeable personalities. I would like to thank the officials of the Standing Committee for Scientific and Technological Cooperation of the Organization of Islamic Cooperation, especially Mr. Professor Dr. Muhammad Iqbal Chowdhury, for giving me this opportunity to attend this gathering and witness the opening of an important scientific event. As you know, the main goal of this committee is to help in promoting of bilateral and multilateral relations of Islamic countries in the development of science and technology, as well as scientific capacity building in the Islamic world. And so far, important steps have been taken in this field, and there is a long way to go. The countries of the Islamic world are full of talent and human capital, which should be well exploited as the main factor in the development of countries. The Islamic Republic of Iran, as a member of comstech, has always supported the activities of these institutions and hosts the important wings of this committee in the field of intellectual property and the network of virtual universities of the Islamic world. The subject of today's meeting is a very important one in exploiting talents and human capital and protecting the rights of authors. Intellectual property is one of the important types of property that preserves and protects the right to benefit from thought and creativity and transform it into economic value and trading ability. Maintaining this ownership and rights is also of particular importance for the development of regional trade and should be considered by Islamic countries as one of the main prerequisites for the development of regional trade. The Islamic Republic of Iran supports such initiatives and training courses in line with the development of science and knowledge in Islamic countries. I would like to take this opportunity to announce that in line with the development of bilateral and regional trade, an exhibition will be held from 24th to 26th of August in Islamabad, which is a good opportunity for the presence of knowledge-based companies from Pakistan and any other Islamic countries to get to know each other's capacities and take another step in the direction of connecting knowledge and business. Iran and Pakistan are two neighboring and brotherly countries. These two nations have deep religious, cultural, and historical ties and have been living together in peace and friendship for more than 7 decades. I am happy to announce that this year we are celebrating the 75th anniversary of the establishment of relations between Iran and Pakistan together. Thank you very much. Iran-Pakistan Dosti Zindabad.
Thank you, Your Excellency. I would like to request Professor Muhammad Iqbal Chaudhry, Coordinator General Comstech, to please hand over Comstech yearbook to Excellency. Please. Dear participants, we are now closing this session. Dear participants, we are now closing this session, and after a short break for tea and networking in the lobby, the course work will formally commence at the third floor lecture hall. May I request the participants for a group photo outside the auditorium before going for tea. Thank you.
In that case, Faisal have the right in the territory of Pakistan, and Faisal can, prohibit me to enter the, I have intellectual property just in my territory, in Iran, and Faisal can have rights in Pakistan, and he can ban me. So, but I think, what can IP do? Protect an invention from use by others, copying or everything. Appropriate the technology for returning what invest in the that invention and using it, and control how invention must be exploited. So, we can compare two examples, penicillin and cephalosporin. You know, we all know what is penicillin, who is Alexander Fleming, and the case of the cephalosporin. In case of the penicillin, Alexander Fleming and his colleague Florey didn't get the patent for the technology, okay? And the other company from US get the patent, and they gave, they gave to Alexander Fleming a kind of medical fund about $100K. But in the case of the cephalosporin, Abraham and Newton filed a patent case for the patent, and they start to commercialize it by the help of by the fund they get by Biological and Chemical Research in Oxford, and they can get over 150 million pounds. You can compare this. If we don't have this example, we say that okay, $100 is very good, but we can have more. Okay. The same case happened about the monoclonal antibodies, the lost incentive. Kobler and Milestone, they invented monoclonal antibody in 1975 by the fund by MRC, and they didn't patent it, and they lost the opportunity because after that the monoclonal antibody commercialized very well, and there are many drugs and pharmaceutical products based on the monoclonal antibody. In that way, they missed this opportunity for the intellectual property. So no organization can afford to ignore the IPR. by ignoring the IPR, maybe you don't have any kind of damage, but you lose lots of incentive. So some people, especially who is from university side and who is from industry side, science part.
I have worked in industry for 10 years.
Okay, so most of you are scientists. In science, we say that, okay, I have to do science, I have to do research and publish it everywhere, and government should support their research activities without any limitation, and IP law shouldn't be hindered, I mean the research shouldn't be hindered by the IP law. But in actual, actual word is not like this. IP law is not, it is going to promote the invention, because when, for example, if you are a researcher and somebody, some other people copy your invention, it is you become they limit you, but by the IP law you can promote the innovation, and you have to consider the IP law and IP protection is not permanent law, permanent right. It is a temporary, like patents, we have a maximum 20 years. But if you have a lifelong protection for intellectual property, trademark, trade secret, yeah, copyright, and the copyright is lifelong even after. Yeah. Okay. The second advice is, you remember in the old time they said publish or perish. Okay. And after that they said publish or patent. You can also publish and you can also patent. But which do first? It is better to do 2 to 5 patent first, then you can publish as well. There is no obligation for patent filing that if you file a patent, you never can publish, for example, a research paper. Because scientists at universities all the time are worried about the result of their research. They want to contribute in their scientific journal. They want to publish their research findings. Okay, a patent is not a barrier for publication, but the priority is important. You have to first file the patent. After filing patent, exactly 1 minute after filing the patent, you can publish everything, because at that time you have the priority right. So if you have, for example, unintentionally publish something, it doesn't mean that you publish in a scientific journal. For example, you have an interview in the, for example, in TV about your technology. You are a very prominent scientist, and you were in a conference, and an interviewer by a TV came to you and asked about your technology, and you say something. Is it okay? It's a kind of publication. You can patent it after that.
No, it has already been disclosed.
Any kind of publication may even hurt yourself, even if you yourself disclose your invention. You must say nothing about that in a meeting, in a conference, or a presentation with venture capital, for example, in a bank when you want to get some kind of grants or everything. But if unintentionally you did something, is there any solution? Or you're ruining your technology?
It depends in the country-wise. As we are mentioning the grace period, so in US there is 1 year grace period. I think in Canada also there, but in most of the countries there is no grace period for that.
What's your name?
Dr. Sohail. Dr. Sohail.
Sohail. Dr. Sohail is the TA of the class. Okay. Yeah.
Dr. Sohail actually is one of the, let's say, most learned person I've met with regard to the patent law. And he was actually also at the patent office for a long time. I think he was last at the patent office. He was assistant controller.
Mhm.
I'm not exactly sure, but yeah, so he is the guy.
Actually,
Okay.
I joined
No,
in
no,
2003.
maybe he's professor. I can see it here.
I started as patent examiner actually in 2003. So for the last 19 years, actually, I've been dealing with patents. That's my village.
Perfect. So he is the observer of the class. So, okay, if you have to publish something, for example, you are a professor at the university, you have a grant, research grant, and the office told you, we cannot pay the money unless you publish your, article, or you have an, for example, PhD student, he or she wants to defend the thesis, the final thesis, they have to publish an article in a scientific journal, and they have to. It has the technology has the capability of being a patent. In that case, in some countries, we have grace period. What is grace period? Grace period is a time, for example, in US, it is 12 months, and in Iran, we have 6 months. In some countries, we have 9 months. That if you disclose something about your invention, just you can file an application during the grace period. But please, I ask you, please, not to publish anything for the whole for grace period, because in some countries we don't have grace period, like Pakistan. In Pakistan, we don't have grace period. What about Uzbekistan? 3 months grace period. What about Malaysia? 6 months.
But there's a question, if I may.
Yeah.
So let's say I file my first application. I'm a Pakistani, and the patent office allows me to go and file an application in the US, for example.
You as a Pakistani, you
I'm
don't.
not filing in Pakistan.
You don't. You started from US.
Let's say I disclosed in the US.
Mhm.
Let's make things a bit complicated. So I disclosed in the US. There's a grace period. I file, and then within the grace period, I file in the US.
Mhm.
And then I go to a country where there's no grace period.
Like Pakistan. Okay.
Like Pakistan.
Let's ask
what
the
happens
participant.
there?
Okay, what happened in this case? Did you guys get the case? For example, Dr. Obes, a Pakistani person. He is in US, for example. He disclosed something about his technology in US before filing a patent. Because in US law, they have grace period for 12 months, okay? He can file a patent in US. And after that, because Pakistan is the member of Paris Convention, and in the Paris Convention, we have 12 months after the first filing, you can go to other 192 countries, okay? He wants to come to Pakistan to file a patent. Is it possible?
No,
Others, you said no. Why?
because Pakistani patent application should be hit by the prior art disclosure in US.
But in US, we have patent application.
Yeah, but that was subsequent because that is it, territorial in nature.
Exactly. Because in patent system, the first criteria is novelty, okay? And the novelty is absolute novelty. It means that nowhere in the world, in tools, not just scientific, even oral presentation. In that case, you can file in the US and you cannot file in Pakistan. What about Europe? In Europe, we have the same case because in EPO, we don't have grace period. So grace period is good, but it's not a total solution for every kind of disclosure. So through the Paris Convention, we can file a patent during 12 months after our first application, okay? For example, I have a patent application in Pakistan. I have 12 months time to file in other countries. I want to file in 50, 60 or more countries. Is 12 months enough? Because you have to go through different, offices in different countries, one by one, okay? Is there any international patent that by filing one application, you can get a right, you can get a right in whole the world? Is it, but PCT. Oh, 20, I think it's
125.
He's saying members total PCT, but they are 150%.
154 member states. I think they just, like in last month, we have one new, I forgot the name of the country, but I think now it is 155, okay? Maybe some of you heard about the PCT, Patent Cooperation Treaty. Remember that Patent Cooperation Treaty is not the route to granting an international patent. PCT just is a route for getting international application, and it extends the time for you for 18 months to apply individually in different countries, and it has its own flexibility to have one application, one search system, and decrease them, but it is not granting a patent. And they don't any guarantee, for example, if you apply to PCT, and for example, you choose, for example, 50 designated countries, all 50 designated countries must grant a patent to you. Maybe 20 of them accept and 30 of them didn't accept. So when we are going through the patent application system, it has a very complicated and sometimes very time-consuming procedure and expensive. So we have to choose. And based on the Paris Convention, just we have 12 months. And if we are member of the PCT Convention, we have 18 months to file patent. After 18 months, even me, as an inventor, as an applicant, cannot file patent in other countries, okay? So we have to choose. And there is a lot of money. I mean, the cost of the patent is very high. So this is the place we have to choose between countries. How we choose that which country we should enter and which country not? One question. Is Pakistan a member of PCT? No. Remember, so you have just 12 months. But Malaysia is. And Uzbekistan, yes. You have to choose in which country, in which territory, and how many applications. If, for example, I invented this cell phone, if I just file one patent for this, without any exaggeration, this cell phone consists more than 5,000 patents. Okay, it is not just one patent. We have different patents. And normally patents are not about, for example, we don't say a patent for a diagnostic kit for corona, a patent for a corona, for example, vaccine. We just have patent for some process, some ingredients, some components of because in that way we can use that patent in different fields. And we can go through the different countries. Okay, which country I choose to go to? In the countries I have going to export, I'm going to produce, I have market. Is it enough? I have market, export.
Country who can potentially manufacture this.
We have a strategy in patent filing. This is defensive. Maybe, for example, I in Pakistan file a patent and can commercialize my technology. And the main producer of that technology is Germany. I have no chance to go to Germany to produce there, even to export there. But Germany is a main competitor. It is better to file patent in Germany. It is better to file patent, for example, in US. Why we file patent in that countries and we have, no or less opportunity to go there and doing commercial activity? For some reason, because it is the, there are competitors, or in countries like, for example, in US, many technologies are there, many companies are there. If they want to do something, if they want to improve their technology, my technology is there, a kind of limitation. They have to negotiate to me, okay? They get license or buy my technology. In that way, I can commercialize in indirect way, okay? So in choosing the destination and designated countries, the defensive strategy is very important as well. So when I want to protect intellectual property, for example, in my cell phone, just patent is enough? Actually not. One product is not equal to one intellectual property. As I said, there are more than 5,000 patents inside this cell phone. But other forms of the intellectual property, also we have trademark and copyright for the application, design for the shape of the cell phone or even the shape of the application, and maybe there are some trade secrets. We have to be aware of what other types of the intellectual property, even some of them are confidential, we have to protect them in a non-registered way of the protection, okay? Number 5, be aware of infringement. I infringe the others and also others infringing me. I have to be aware. I have to monitor my technology. Sometimes I don't use my technology, but the others use my technology. In that way, I can file a law case. Yes, but it is good strategy. File a law case. Is there any lawyer here? Okay. Filing law case is very expensive, time consuming, and maybe at the end there is nothing for the plaintiff and plaintiff, okay? But in the technology, when there is an infringer, technology owners try to negotiate with each other. Maybe in that case, they can have cross-license, sub-license like this. For example, in the case of Apple and Samsung, in the case of the Canon and HP, mostly they don't file law case. They try to negotiate when they have infringement and they infringe each other, and they ask for a free license, royalty-free license. It is a kind of a negotiation. So, number 6, check employment and consultancy contract to retain ownership of IP. It is very, very important. Imagine I am an architecture, okay? I build a house for myself or somebody from other people or the people. I am the architecture and I am the owner of the house, okay? I sell my house to Dr. Obes. Who is the architecture? Who is the owner? Dr. Obes sell the house to Fatima. Who is the architecture? Me. Now, who is the owner? Fatima rents her house to Mr. Dr. Shatta. Who is the architecture? Who is the owner? Fatima. Who is the utilizer? Ownership, inventorship, and benefit sharing. Sometimes people at universities or even in the industry mixed up this context. These are different contexts. Ownership and inventorship are different. So in this case, who is the architecture? Inventor. And the owner is the mostly legal authority have the right of the patent. If you just by randomly search different patent from different countries, and check the name of the inventor and check the name of the inventor owner, you see that in front of the inventor that there is the name of the person, and in front of the owner is the name of the some companies, some universities. Because, for example, imagine you work in a university as an academic person, okay? You file a patent, you are inventor, you are the owner. After some years, you leave that university. For example, go to the other university, go to the industry, go to the other country. What happened to that invention?
I would be the inventor of that, but ownership would go to the university from which I have used those
But
expensive.
in the patent document, you write that you are the inventor and you are the owner. For example, I work for a company, okay? When I want to leave the company, I couldn't get my computer, appliances, and all the devices they gave me and go. They said that you have to keep all them in the industry and you have to go out just yourself. But in the intellectual property, because it is intangible asset, nobody knows that there are some knowledge, there are some assets here. And when somebody leaves the, firm, any kind of firm, it can be university or firm or industry, when people leave, they don't know, okay, they took some of the assets of the university. It is better. The inventor must be an individual person and the owner is the university, the industry. But what happened? I said that, okay, I'm a researcher, I do everything, I didn't sleep at night, I do research, I do everything, but the owner's university, when they commercialize it, there is money, there is nothing for me. I don't want to disclose my invention to university. I want to go out and file it myself. Is it possible? Yeah, in some countries they do that. What is the solution?
In my university, we have the policy. The policy states the profit sharing between the university and the inventor in case of commercialization. That policy.
Is there any other policy?
I think in this regard, the university's intellectual property policy comes into play. Because inventor or researcher, they have to sign an agreement with the university. And if it is written in the university policy that you cannot go and you cannot file that individually, then he has to go through the university.
Okay. Inventor in
There's a very interesting provision in the Pakistani patent law, I think section 12. It provides three scenarios. So one scenario is that if an employee has an employment agreement, in that case, because of the agreement, the invention will belong to the employer. If there's no agreement, then the invention will belong to the
like a student, for example.
Yeah.
Like
We
a
can
student
think
at
of
university.
researcher, we can think of any company, we can think of universities. If there's no agreement between the employer and the employee, then the invention will belong to the employee, unless the employer shows that the facilities were predominantly
Significantly use of the facility.
And even in that case, specifically with regard to the benefit sharing, the employer will share with the employee economic benefits of a exceptionally economical value taken from the exploitation of the patent.
Okay. Sharing is one scenario, but I will tell something about the sharing the somehow ownership.
Would it be kind of royalty, something
I have a
like
question,
that?
perhaps different people in this room. What about students and their thesis and their artworks? So for example, in my university just now, we have art students and architecture students, they're displaying their artwork. Some of them is very innovative, but then what about it? So academics as researchers, we have this point between employee and employer. What about students and the thesis working on? Where does it come under?
About
This.
in mostly universities have IB policy. In IB policy, they define the policies about industrial parts and even copyright, even the materials. the teaching materials of professor at university, who's belonging. Even the thesis of the student don't have any contract with university, but thesis is a part of the commitment of a student at university. So in that case, in some universities say that the copyright belongs to the students and industrial ownership belongs to the university. But in copyright and artistic work, maybe there is no patent, but there is other aspects of intellectual property like copyright, maybe industrial design, industrial, and they can be protected. It depends on the policy of the university. And if there is no policy at university, we have to refer to the master law of the country. I don't know what is the master law. Dr. Oic said there is 3 scenarios.
But that's patent. And in the copyright law, we have section 13, which actually again talks about, you have a very good point, because there the relationship both in the patent law and copyright law specifically is with regard to employer-employee relationship. So even in the copyright.
In copyright in most countries, if there is no rule, it is accepted that copyright the artworks belong to the creator.
Yes, but recently, because of this whole online teaching, there's a lot of online materials and the videos and course materials they have been prepared. So there has been a lot of discussion who actually owns this kind of material. And because there is a growing trend of intellectual property policies being introduced by universities in Pakistan. So most of them, they are going beyond patents. They're even including the copyright within the domain of their IP policies.
If there comes a conflict between the university's IP policy and any other national law, then in this scenario, what will happen to the researcher?
It depends on the law of the university. In some universities, we have board of trustees. I don't know how is the system of governing of university in Pakistan. But for example, in countries like US, European countries, even in Iran, we have the law that we have a master law that the universities are in their official and financial system are independent, and whatever their board of trustees ratify is like a law, and they should obey the university law. And if there is no law, they have to obey the national law. The same in Pakistan.
So, ma'am, I have one more question in continuation to this. For example, if you go further into the other details, we are just talking about the employer or the employee. What about the government employee? The government employee, once they file certain
What employee?
government,
Government.
public sector employee. So in public sector employee, for example, they are the servant of the government, and when they file certain patents and they want to commercialize it, and in that case, what will be the sharing criteria? So there are a lot of complexities in that deal process. Yeah. So the law, probably 1963, something that clearly says you cannot involve into any commercialization or other activity. And on the other hand, being a researcher, you are asked to file, invent and patent, and then again,
the problem I was saying developing countries that law is something different from policy. Maybe by law is, for example, invention at university, in public university, or any kind of public sector belongs to the government. But we know that the governments cannot commercialize, because commercialization needs the interest of private sector. Governments must be like an infrastructure. Have you ever read the book named as Entrepreneur Governments by Mariana Mazzucato? Very nice. It is the story of the Apple, how they develop research, develop technology in GPS and in that sort of technologies by the government, by the support of the defense ministry, and after some time they find some commercial utilization and they came out and become a private sector. And what they did, and after they get good result and good revenue, Then they changed the territory of, the production to Luxembourg, to China. The places they have to pay less money to human resource. They pay less taxes in, for example, countries like Luxembourg. And the government at that time, for example, the ex-president of the US said that they have to bring this facility inside the US because they supported in their R&D time by the government. The government duty is supporting R&D, and after that, the production and manufacturing system must be in the private sector, but they have to define the policies to win-win situation. Because when for example, manufacture, it is better go to run the private sector, but they have to bring money to the government to invest in the next R&Ds, by which means tax. But government is not very good infrastructure, and the problem in the most developing countries and least developed countries is government wants to own everything. And one scenario Dr. Oic said that shaming. In some countries there is, for example, like Iran, and by contract, not by law, by contract they can have share ownership. Okay, for example, in share ownership, me as inventor, as a university scientist, I have, for example, 20-30%, and the university has 70-80%. Okay, we share each other. In the words, the commercialization and industry part have no interest in cooperation and collaboration to commercialization, and intellectual property have, co-ownership. Imagine you want to buy a house, okay? There is two houses, somehow same to each other, the same, same place, same situation, okay? One have just one owner, the other have, for example, 3-4 sisters and brothers and siblings, and they share their house. Who do you prefer by the house?
The one on the first.
The first one, because maybe that siblings have some kind of challenge between them, okay? Exactly this is about the technology. In technology, words and industry don't like to deal with the technology, have a lot of owner, because you have to deal and negotiate with different people, okay? But the revenue sharing is the solution. In that case, for example, industry, university, or whatever have the ownership, researcher have the inventorship, and after that, because researcher is researcher, when he finish one research, he should start the next one, and he don't have essentially the ability and capability of commercialization, negotiation. Do you have this all these capabilities and skill? Do you have all the skill of the law writing the contract? You have to pass it to the other offices. For example, TTO, you are the head of the TTO of university, okay? In TTO, they know where is the market, how to negotiate, writing a contract, okay? And they start to commercialize, to bring the industry to university to make a contract. But after commercialization and money came back to university, okay, and after decreasing putting out the cost, because we have cost for patent, we have cost for negotiation, we have cost for example, writing agreement, and after that we have revenue. And this revenue divide between different stakeholders. Who are the stakeholders? One of the stakeholders are researchers. One of the stakeholders is TTO, because TTO do such kind of activities. If there is no share for TTO, IP office or TTO, TLO, any kind of the names they have in different universities, they don't have any incentive to do more jobs, okay? And some part of it go through the department of the industry, of the inventor, researcher. Why?
Because they provided all the equipment, money, and all those things.
Equipment, starting new projects, and some part of the revenue sharing goes to the dean of the university. For what? to develop the university, new department. For example, in my university, there is no new technologies department. I want to initiate it and to launch the new department used for that. So benefit sharing is the best solution other than sharing ownership. Okay. And the next part is a strategy. Everything depends on the strategy. Imagine in a university, in a company, we have different resources. Human resource, the company staff, financial resources, tangible asset like buildings and equipment. There are other resources. Now we know that there are other resources, which name is intellectual property. We have to, when we are going to initiate our companies, our university strategy to business plan, we have to consider intellectual property as an asset beside to other assets. In business plan, we have three main parts: managing of the business, operation of the business, and growth of the business, we say vision. Do you think that we have independent intellectual property business model or strategy at our firm or university? No. Intellectual property strategy and business model is inside the business plan and business model of the of my firm. It must be connected to my other strategies. So in intellectual property, again, we have management, operation, and growth. So it's just activity for the intellectual property is register. So if we say intellectual property, we say that intellectual property is not limited to patents. Okay? Now we know that intellectual property has different types. And IP management is not just register. We have 5 different activities. Okay? Identifying the IP. Have you ever heard about the IP audit? IP audit is a kind of mirror. A person who is expert in that field put in front of your company, in front of your university, just to show you what type of intellectual property you have, what potential IP you have. They didn't do anything, they didn't register. And the second activity is securing the IP. For example, you are working in a department, in a laboratory, and that sort of things. You have kind of, you know that you have some kind of IP, okay? You have some kind of information. You know that, okay, if it is in computer, or it is, she is my colleague, she has some knowledge, she has some information, we have to have a contract with each other. Not very officially one, if we write down something, even in an email, okay? And after that, we have to register. Not all the IP must be registered. It depends on the cost-benefit analysis. Maybe, for example, some IP, it doesn't work filing and paying because the patenting system, especially patenting and IP protection system, is very expensive. You have to choose what's your strategy. Is it worth that you pay money to keep this IP for nothing? Okay? And registering is not enough. You have to know how to protect. What is the difference between registration and protection? For example, you have a car, you have house, you have the document, the certificate that shows that this car belongs to you. This house is belong to you. Do you, for example, when you go out, you lock the door of your house. Okay? You don't say that, okay, I have the certification document, that house is for me, that car is for me. No, there is no theft. Maybe there is some theft that steal your property. Protection is something different by registration. Protection, remember it by monitoring. And the last activity is exploitation. Exploitation not all the time means that you produce yourself. There are some direct and indirect way of the protection. Have you ever heard about this cake? the whole cake, a whole of a small cake, and a piece of a very big cake. Which one is better? What does it mean? It means that I can produce and leverage my intellectual property in a direct way by myself, for example, produce it, but there are still other ways to leverage more. For example, I'm from Pakistan. I don't have any company, for example, in China. Even I don't know their language. I don't know their market. I don't know what is their capability. I negotiate with a company in China and give the license to them in that territory. I don't let them to go, for example, to Uzbekistan or other countries, okay? I said that, okay, the market of China is for you, that because you are a Chinese company, you know the market, but we can share the benefit in that way. In that way, you make your cake bigger and bigger. So it is intellectual property. We have some tactics and techniques depending on the IP law and the strategic management inside the company and outside the company. There are some taxing, licensing, litigation. In litigation cases, sometimes, big companies like, for example, Apple, Samsung, that sort of companies, sometimes they don't commercialize. They get revenue by fighting cases. Okay, there are a business in the world that people just monitor, that companies just monitor others, people, intellectual property rights, and if they find an infringer, they file a law case, and that way they get finance. But what about the internal part of your company? The first and important thing is knowledge. If the people you are working with, even students, researchers, even the administrative people, if they don't have enough knowledge about what is intellectual property, maybe you have leak and you don't know what you have. It is the first part of the the IP awareness is very important to file and to find more cases and file more IP. So at first, when somebody entered the university or entered your industry, no different than a student or researcher, they must have a very general short training course on the intellectual property. And the seventh is be aware of your environment. Sometimes you have an invention, you have kind of intellectual property, but the other competitors around you don't say like this. You do something, you commercialize it. They are doing some activities. Okay, you must be aware that how can you deal with them? Maybe a kind of a strategic alliances, a strategic collaboration. And maybe there are some empty parts that nobody is there in that territory. You can go and get there, even if you don't have a special activity in that part, because it is an empty land. You go and get there. We call it invent around. For example, you have an invention, so invent around that made invention in the part that is the land is empty. The other evaluation is very important in collaboration. When you want to collaboration, for example, when you want to sell your house, when you want to rent your house, okay, when you want to rent a house, how they evaluate that house, depending on the geographical places in the city, depending on the how many square meters, and depending on the facility, okay? Always the same. If you want to buy and sell a license, at first you have to evaluate. But is the valuation of intellectual property same for everyone? No. Maybe I need the technology, you don't need that technology. This technology is very essential for me, so it values for me. You can sell it to me very expensive, but it is not a very essential technology for she. So you cannot sell it in an expensive price. Leave litigation to lawyers, but not in isolation. What does it mean? In the first rule, I said that you all the time have to use expert people in the solicitor system and the patent attorney. But you are the person, you are the authority who all the time must watch out what you have. And in the case of challenge, in the case of mistake, in the case of collaboration, you have to use that. But so in that way, you have to have some knowledge to prosecute your case. And the rule number 9, the exploitation. I said that sometimes you use in-house, or maybe you can use in indirect way by licensing for more revenue, for lack of resources. As the example I give you about the China, because you don't have any special resources to interact the licensing. Sometimes you started a collaboration with competitor to control it. It is very important. Do not let them to be a competitor, be your strategic partner. It is very important. And sometimes the technology is outdated. We don't put the technology in the rubbish. Okay? We release it. Maybe, for example, I'm Germany and this is India. I don't need this technology. Okay, black and white TV. I have colorful TV. But in India, for example, there are lots of people, their daily earning is less than $1. The technology can be used there. So in that way, I don't put my technology in the rubbish. I can assign my technology to the other. So there are many solutions. We have to consider about the consequences of every solution. We have to choose between that. We are going to internal use, the spin-off company, to collaborate with the large industry. What is the solution for the leveraging from the technology? And the last point is around rule number 10. Remember that license involves learning. Licensing is something different from buying. When you start collaboration through licensing with a company, if you cannot learn from that technology, learning means that if you get that technology, you can improve it. If you cannot improve the technology, it is not licensing. It is just buying and selling. Okay? You have to start learning about technology in that way and be aware of that. For example, I get the license from that person, from Sohail, Dr. Sohail, and in the contract, we have to define that if I can give sub-license to others as well, and Sohail must pay attention that if he give me the license to technology and I make the some improvement, what is Sohail right? Is there any obligation to license back to Sohail by free royalty or by royalty? There are some interest by the licensee and the licensor. Licensee wants to pay little, it's obvious, and catch up a lot, have more improvement and learning a lot. And the licensor wants all the opposite. Okay, is there any zero game here? I want this, you want this, it's minus, it is plus. No, we can make a win-win situation. Like the example I gave about China. Okay, my presentation finished. I just put a conclusion and I put that 10 rule and some important rule here to, if you want to review very quickly. If there are any questions, we just run out of the time. Having IP strategy or IP policy, you know, what is the difference between strategy and policy? In the federal level, we mostly use a strategy. In the government level, we mostly use policy. In the sector level, in the industry level, we mostly use policy. If you don't have IP strategy, it doesn't mean that you cannot do anything. You can do it. But if there is any damage, it is a big damage. Okay, remember, IP strategy is very important. Okay, any question?
Yes, I have one question, please.
Yeah.
Well, it is well known that when we are filing a patent, it should not be a prior art. This means that we have, for example, I am a researcher and I have not disclosed this information in a meeting or in an email or in any document, for example. Let's say that one of my MS students has written the thesis on that paper, and that thesis is nowhere on the internet. Or I have presented the work in a meeting and there are no reports on the internet. How do a patent filing officer confirms that this is not a prior art? For example, if I publish it, okay, everybody
Okay,
knows
I
it.
see.
So how does it go? And if, for example, they didn't find it, will I be able to still get a patent or not?
Okay, when we say prior art means any information accessible in the public. Okay, public access. If there is kind of private communication through email, it is better to write that, okay, this information is confidential in the title of your email, okay? Or in the negotiation, even in the oral, anything is in public, that examiner can find it, okay? It is prior art. Other than this is not prior art. Because, for example, it's a kind of negotiation between you and your student.
And sometimes it also happens that the patent filing officer is not competent enough to find it on the internet. It's somewhere lying.
Exactly.
And then what happens that it is discovered after 2 years that it was already.
Very good point. For example, Dr. Sohail is the examiner. Dr. Shatir, go to him and file a patent. Okay? And he granted a patent, Dr. Sohail granted a patent for Shatir. After 2 years, Dr. Owais came to Dr. Sohail and said that you cannot grant a patent to Dr. Shatir because I find a prior art before Shatir filing. But now Shatir has patent. What happened to his patent?
Post-grant opposition or litigation. In Pakistan, we do have a revocation procedure, so you can revoke.
You can revoke the patent. You can invalidate the patent.
Yes, we have different provision at 3 or 4 levels actually. First provision is at the time of the acceptance and publication of the patent. In most of the countries worldwide, after 18 months before acceptance or allowance of the patent is published. But in Pakistan, we don't publish before allowance of the patent. So
in 18 months.
Yes.
Like Iran. In Iran, the same.
We don't have the time limit.
Yeah, exactly.
Once it has been accepted, it is published publicly, and we have 4 months of position period before grant of that patent. So first stage is that if someone during that period wants to, he can oppose the patent. Second stage is
we have the same for 1 month, but in our new rule, we don't have that.
we have 4 months actually. So after that, once that patent has been granted, then within 1 year from that grant, again, if someone finds that patent is not granted legally and there is some prior art, he can go to the patent office and file a petition with the controller of the patent.
We have the same in Europe. It is for 9 months, I think.
So after 1 year, then if still there is after 3 years, 4 years, someone finds, so he can go to the court actually. And he
By
can
not
file a
using.
petition. Yes.
Exactly.
So there are 3 different levels to oppose the patent.
To
actually.
invalidate.
Even, at the 19th year of the patent.
Yes, we have the same in Iran. If there is, for example, you file a patent and for some special years, you don't use your patent, especially in the field, for example, in the health or in the, the security, if they don't use and the other competitor wants to use it, not everyone.
That's compulsory license. Maybe.
Yeah,
Then we
compulsory
have the
license.
provision in our law as well.
And we have the other article for the obligation of using the patent rights. But because of that, I said it is maximum 20 years. Because in any way, if you have the granted patent, the document, the certificate of the patent, anyone, in any case, if they find kind of prior art, they can revoke it and invalidate it. And even you yourself, that if you have the the patent certificate, you have to renew it every year. If you don't renew it, you have no more right, okay? So maybe after, for example, and the price of renewing and the cost of renewing increasing every year. For example, if this year I pay, for example, 1,000 rupiah, and I don't know if it's good money or not, next year will be 2,000. The next year is 3,000. Why? Why it is increasing?
Maybe that person having a profit.
Yeah, because when you go and renew the patent, it means that you have commercially benefited. So you have to pay more money. Why you have to pay more money? What is the patent system logic? The patent system logic is that here is private right, here is public right. You give the public right to access to the knowledge, to use that knowledge commercially, and give all the right to the patent owner, I mean the inventor or the university or everywhere in the individual or legal entity, okay? If they use it, they have to pay more money, and money goes to public, okay? It is, and after, for example, five years, my technology gets outdated. Maybe I don't want to use it, then I don't renew it, okay? And in that way, there is no, because of that, I say that don't say 20 years, don't say maximum 20 years, okay?
But maybe I add one point, please. As we are talking about that maximum protection is 20 years, but in some countries the provision is there. For in US, actually, you can go beyond 20 years as well, and that is specifically for
In some cases, pharmaceutical, yeah.
Yeah, that's specific.
Yeah. But in before TRIPS agreement, there are different years, even in some countries less than 20 years. One of the TRIPS provision that because as I know, Pakistan is a member of the WTO, and the TRIPS agreement is a one prerequisite. In TRIPS agreement in Article 876, something like that, and the minimum year of the protection. That area, in that area, it's that the minimum 20 years protection.
Actually, before signing the TRIPS agreement, Pakistan was having 16 years protection.
16 years.
So
After
implemented
TRIPS, you
that
have
in,
to.
that started in 2002, I think. It was signed in 1995, or practically it was implemented in 2002.
After TRIPS agreement.
Could you briefly elaborate the difference between intellectual IP policy and IP strategy?
I said that this is just a wording. A strategy mostly used in the firm level, okay? And policy mostly used in the government level. Policy level, we say policy level, firm level. Okay. Sector level. Another question?
Yeah, I have a question which is a little different from what we've seen in the developing world is that we have limited science resources and science and technology. Different departments will be working on the same issue, same thing, but they don't know. Have you, in your experience, seen that you use some sort of IP management tools so that different departments know that somebody's already working on this, maybe we can move ahead? Is there some sort of example?
There are some platforms. For example, do you have any experience, Dr. Shatter, in your TTO in Malaysia about, for example, there are different departments in one university or, for example, in one industry. They are working in somehow similar or same field of research, but they don't know. It's kind of reinventing the wheel and the waste of the resources. Do you have any solution for that?
I never come across it. Yeah.
Departments are working in their speciality, they have no overlaps.
There are some overlaps, maybe, but so far we serious issue. Yeah.
I don't know about Pakistan, but in Iran University we have institution, I mean the structure of research council. Every project before starting, the proposal by the researchers must go to the research council, okay? There are some members, and the members are from that research department, and the legal person, for example, head of the research, for example, management department, and all the researchers go, a proposal goes there, and they assess if there before we have same researchers, or is there any other researchers in the other different department, and they read the proposal. There are some referees, assess the proposal, check even researchers out of the university, if there is in other universities working in the same field. If yes, they don't accept to pay money, to grant that research. In Iran, it is the official procedure at universities, I mean. And in granting bodies, I don't know, in Pakistan we have granting bodies, right? Yeah, in granting bodies, they do the same.
Yes, we have funding agencies in Pakistan as well. The major funding agency is HEC, that's Higher Education Commission, the Pakistan Science Foundation, COSTECH. So there are few funding agencies that definitely when someone submits the project, they check it and they have.
They don't pay money to reinvent the wheel.
Sorry?
They don't pay money to reinvent the wheel.
Every submitted project is not funded.
Exactly.
There's a selection.
We run it through Turnitin, and then we look into the similarity index, because most of the universities, they do have databases for thesis and their research publications, and these are available on public repository. So once we scan it, we can know it that whether and it is also compulsory for a project that we also submit a similarity index
After finishing, yes?
No, just because we are once we submit a project for funding, we have to add the similarity index, and then they look into that whether this type of research has been conducted in Pakistan or anywhere else in the country, and then they fund.
Exactly.
The inventor of a patent is always a person. The owner is generally or organizational university.
It can be a person, can be a person.
So the owner can be a person as well.
Yes.
So, okay.
We can have individual inventors, for example,
So,
a person
for
who's not
example-
from the university or industry.
So for example, if some person from university or industry does some work in his private.
In what case? This is very important. I am a researcher in university.
Yes.
Can I have a patent with my own ownership?
It depends on the university policy also.
It depends on the field. If, for example, I'm a researcher at university, I'm a, for example, pharmacology, for example, scientist. But I myself, individually, I'm interested in somehow the design or the other field, other than the pharmacology, not related to my mission, not related to my contract with university. If I do something in the time, out of the university time, in that case, I can have a patent with my own ownership, even in the same field. We have the word significant use. This significant use related to using of the infrastructure facility, even the knowledge. Because when I am working for a department at university, it is a kind of accumulative knowledge. Because some part of the knowledge came from the interaction of me and my colleague. Finish?
Well, I belong to Punjab University, and my job is kind of convince teachers or researchers to get patent. They get their research patent. We have a kind of problem that our teachers or researchers mainly focus on getting their research published, getting their research journals.
Everywhere in the world is like that.
So when we ask them to go for patents, you cannot publish your journal yet, or at least goes at least 1 year forward or something like that. And secondly, you have to pay a lot of money. So how can we convince and we can solve these problems?
There are different strategies. Some of them are top down, and some of them is downtown. Let's have down this IP policy. Okay, when you are a researcher, a student or researcher, if there is IP policy, it's kind of obligation. We have to do that. Okay. Down top strategy is IP awareness. You have to tell them, you have to teach them what is the benefit for themselves and for university totally, because after sometimes they can get benefit, you know, publishing the scientific article in the scientific journal is a kind of short-term incentive. Okay, after 2 months, 3 months, 6 months, I said, okay, there is in my article in that journal, okay, I can get some, for example, marks in my evaluation system at university. All the scientists like this in all over the world, not Pakistan, all over, even the most developed countries. In the patent system, they can get more revenue, more incentives, but in midterm or long term, okay? And they must be aware that they can publish after application. It doesn't need to wait for patent granting. Exactly 1 minute after patent application, they can publish. So awareness from raising awareness in the down-top approach and policy from top-down approach, these two together help the situation. It is kind of culture, and culture need time.
So you want to say that after filing application for patent, they can publish their article?
Yeah.
It's not, they don't need to wait for that, get patent, patent over there. They don't have to wait for that. Just filing is enough.
Yeah. And the flexibility of PCT is that by filing PCT, you have priority in 154 countries. Priority, not patent, but you can do anything.
PCT stands for
Patent Cooperation Treaty. And unfortunately, Pakistan is not the member. And is there any solution? Think about the solution. Fatima will give you the answer. Okay? Yes. Think about the solution. There are some different solutions. Any question?
Ma'am, what is the role of NOC, no objection certificate for using
Role
any
of?
patent? No objection certificate, NOC, for using the patent of any person.
NOC.
हमें जब किसी का कोई पेटेंट हमें इंट्रोड्यूस करना, मतलब आगे उसको हमने अपने इसी रिसर्च वर्क के लिए तो हमें NOC लेना पड़ता है.
There is many kind of NOC actually. You need a permission actually. You need permission to use for non-commercial use. So for non-commercial use or for research purpose, you don't need to take a permission for it. Patent is only for the commercial interest.
Yeah, by law, you can use anyone's intellectual property, I mean the registered and protected intellectual property for non-commercial use. For example, for educational, for research purpose, you can use it without any permission. Yeah.
But sometimes they disclose in their patent or in their publication that you can use it for education purposes.
Yeah, it's
And
true.
for any commercial use, you have to seek the permission.
They don't mention actually. You are protected in law on research purpose and non-commercial use actually. If the use is different, if you are going to use it commercially actually, then you have to negotiate and take the license from there.
No, I am talking only for use in my research.
Then you have reference of that patent, and that will be okay. Proper reference is important.
I want to say something. Imagine this glass without this handle, okay? Imagine it is patented by Dr. Sohail, okay? What's your name? Sarah? And Sarah is a researcher, okay? She's doing research on this glass, okay? And she used this just for research without any permission from Dr. Sohail. And by improvement, she adds this part to this, okay? Does Sarah, can Sarah produce it commercially because it is not the invention of Dr. Sahel? Yes or no?
No.
What is Sarah's invention? Just the handle. Sarah can produce just handle without glass. What is the solution?
It is useless definitely. Then Sarah will go to the actual owner, to the Dr. Sohail, and definitely they will negotiate because
Ask for license?
Yes, definitely for license
Or maybe sell with
mutual-
her technology.
Of course, she can sell. There are multiple options over there actually. They can
Remember.
usually negotiate.
Yeah. Remember, if you are working on improvement to others people intellectual property rights, okay, and if they are alive, and if you add something to that, you are not allowed to produce that because you have patent. You have patent just for the improvement part, okay? For producing whole of this, you have to negotiate. Maybe you have some kind of cross licensing, you both can produce it, or maybe you are a researcher. It is a good opportunity because he is a producer. He said that, okay, I invent this part, you can make, improve and better a product by giving the license, or even you can assign your whole right to Dr. Sohail as a big player in the market because he has the brand, for example, in the market, but you don't have that, you are just an inventor.
But what if she is giving based on the idea?
Person will give royalty to that person who has improved this thing.
Give right, yeah, she can have patent for this. And do you remember we talked about the utility model?
Yes.
Maybe it doesn't get patent, but she can get a utility model.
And what about if
Just
the
by that.
patent protection time lapsed?
Again,
If the patent protection time has lapsed,
okay, you can use it. After 20 years, or even in any way you can invalidate the patent, you can use that.
maybe if there
Well,
is a
you
patent.
have partly answered already because she made a handle and she goes to him and tells him that I have invented this. She doesn't have the utility model, and then he cheats, and then he takes the, because it's not already patented, he just adds up and then just do the business and just ignore the Sarah.
Now, in that way, Sarah can file a case.
And if there is a patent present already on individual plant-based products. For example, there are two drugs that are already commercialized based on the natural product by plants. And I want to make a new drug by synergizing or combining these two products to make a new drug or product.
Okay.
How can it be?
Combination. You know, today we don't have any.
Because I used to work on the synergism.
Because it is content part of the patent. Maybe I don't think, but maybe Fatima covered that part. In combination, in some countries, they said that in the bylaw, they said that the combination of two inventions, if there is no added value and no other inventive step, it doesn't fulfill the patent criteria and we didn't get patent. In the biological field, if the resources is natural, okay, the resource is natural, it depends on the rule and it differs a lot. And by the biological, essential biological, maybe you cannot patent unless you give a special application. For example, you use that biological material to invent, for example, a drug. Okay, not just you have to manipulate that. You cannot patent the essential biology.
And the same drug, a new use is identified.
New is a big challenge in the world. Some countries accept new use. In Iran, no. But in Brazil, you can. And for the type of the claim, they said that Swiss type claim, second medical use. Any other question? Because we don't have time. They were very active class, actually. Very active class. I hear a lot. Okay. Any other question?
Yes, I hear something. It's very interesting. I think we were rarely seen such a discussion actually.
Yeah, I'm really impressed by discussion. That was very good.
Is that you continue with this discussion.
In the break time.
During the lunch,
Okay,
we
yes.
have tea is running tea. So we are not from tea break. Anybody who wants
So
to
there is
have
no
tea, there is tea outside, you can just pick a cup of tea and have it. But we are already running 30 minutes behind schedule. So
I use all the time productive always.
You just left, yeah, 5 minutes.
But I asked you, do you have a presentation about Pakistan at work?
Yeah. So what we can do is we can take a quick 2-3 minutes break.
Yeah.
Whoever wants to have tea, bring it in, and then we start the next.
You know, the break time and the lunch time is the networking time, okay? We are here to answer the question.
2 to 3 minutes, and there's tea on that side, so you can bring the tea inside. So, officially, I should not be standing here because my session is over. But I'll try and do it as far as possible. The good thing is that we don't really have a tea session, and that's why we brought all the stuff inside the room.
But we have a big and heavy tea session before that.
We did. So that's why Mitra actually took the opportunity to steal the next tea session from us. And we're thankful to her for that. My name is Dr. Abhishek. Yes. I'm very honored to have been invited for this course as a resource person, but that's one thing that's I feel honored. I also feel honored because Professor Hafiz is sitting here. He was one of the very first trainers for me in IB. Back in 2006, when I joined the IP office, the IP office actually asked us to go to the International Islamic University, and that's where Dr. Saab and I interacted for the first time. And since then, he has been, his impression has been on my work as well, somehow, off and on. And then I have Professor Sarva. Professor Sarva is senior most professor at the HEJ in Karachi University. In the absence of Dr. Iqbal Chaudhary Saab, she's the runner of the show. And she has always been very kind to me. And she gives me time and gives me complex problems to solve when it comes to patenting, very complex one issues now. So Dr. Professor Sarva, thank you very much. Sir, last but not the least, I'm really thankful to Maisa Saab for joining, or of course, Dr. Suhail Chaudhary Saab, who has been my colleague for some time back in the IP office. So, my name is Dr. Wes Sheikh, and I am currently working as an associate professor at Zabul. Zabul is Shaheed Zulfikar University of Law, which is different from Zabas. Zabas is okay. So we are a public sector university focusing on law primarily. Yes, it's a public sector university. We're focusing primarily on law. I did my PhD in IP law from LMU, which is in Munich. LMU is the same university where Alaa Iqbal also does PhD, so that's kind of an honor for me again. I also did my LLM from Augsburg in Germany. Before that, I did my BBA and MBA from IB in Karachi. I'm also a tutor at WIPO since 2015, where I tutor actually intellectual property management course twice a year. Professionally, I've been associated somehow mostly with government institutions in Pakistan. So first IB and now public sector university, and all those who actually are at the public sector university understand the interesting life that we have as public sector employees. I've shortly also worked for as a management consultant with Siemens back in Germany. Yeah. So the focus of my talk will be on Pakistani innovation landscape. So we'll be looking at Pakistani patent data for the last 20 years. This data has been sourced from publicly available sources in Pakistan, but the data is scattered, obviously. So what I did in the last 5 years, I built a database by myself of all the applications from all applications starting from the year 2001 till now. So the database keeps updated, keeps getting updated, and using that database today, I'll be giving you some insights. I'll be posing more questions than I'll be giving answers. Now to try to take more. Actually, I have my notes on the slides. I would like to have them presented to you. So yeah, so why am I using that data and presenting today in front of you? So there are two types of researches: qualitative and quantitative. Quantitative research tells you what, it kind of poses questions because we don't really have a lot of answers just by looking at the data. But the data is giving you the very first step from which you can actually go into qualitative research and ask why. So a lot of my slides will be posing, and I'll be posing questions to you, and then I will also be sharing my theory of what could be the answer. And I would also like you to actually contribute what could be the answer to those questions. So it's very practical. The data is the slides are very practical, as you'll see. Almost all the slides are like this. So yeah, let's start from the different stages of patent filing. So it's very summarized form of different stages. I've kind of put them in big chunks. And even in these stages, I will only focus on data from application, publication, and grant, because for two reasons. One, that there's a paucity of data on publicly available on all stages, and then we also have paucity of time. I'll try and finish in the next 20 to 25 minutes, and then we'll take questions. So this is the general data with regard to applications, and the period is from 2002 to 2021, last 20 years later. This actually shows you some interesting trends, and in these 4 years, we really had applications that crossed in these 3 years almost 1,500 applications, and this can be seen as the golden era of applications that were received in Pakistan. The orange part is the resident application. Can somebody tell me the difference between resident and non-resident? So what does that mean? Who are residents and who are non-residents within the patent process? So applicants having a Pakistani nationality, domicile, any connection with Pakistan, those applications are resident applications. Applicants and those applications are resident applications. All the others are non-resident applications. So we do see that the share.
Non-resident, is it coming from application from outside of Pakistan?
Yes, non-residents are all coming from outside of Pakistan, and residents are those applicants from Pakistan.
They are filing those applications in Pakistan, but they are not residents of
Oh,
Pakistan.
yes, all these applications have been filed in Pakistan. We are only looking at the Pakistani data. Okay, so it's only Pakistani data of the last 20 years. And then this part, this color is all the non-resident applications, which means foreigners are filing in Pakistan. And this is orange, which is Pakistanis are filing in Pakistan.
So foreigners are too much into it.
Yes.
So what's the
Good question, and I was not expecting questions to come out like this, but a good, very good question. Why foreigners were filing so many applications in Pakistan? Even though if you look at in the absolute numbers, right now, and for example, last year, for the last, I think, for the last almost 8 years, we didn't cross 1,000. The magical figure of 1,000 applications. And if you look at, for example, China, in China we see a number of 1.5 million applications every year, and 50% of, I think around 50% of that number is Chinese applications. So as compared to China, for example, we are not even peanuts. Every year application is so we have to look at the absolute picture, not only from Pakistani, not only from a myopic Pakistani number, from Chinese number. Even India is, I think, the total number of applications in 1 year that India received is around 80,000 applications. So from that comment, I don't. So we will open these questions as we go along. Why foreign companies have that interest, or let's say why they are filing more patent applications as compared to Pakistani applicants. But an interesting thing is that this is the same data. This is the same data, but extrapolated to 100% for every year. Okay. So now you can see the ratio of the filing by the foreign applicants, the non-resident and the residents. And you can see that the ratio of resident applications has increased in the last, let's say, in the last 8 years. So you see that increase gradually. For me, again, now the question becomes even more interesting that foreign applicants are filing more in Pakistan, and now they're filing less, and the local applicants are filing more. Why? So that's the question that really goes into my mind. I have different theories. So, for example, in the last few years, HEC actually has started requiring that you should file patent applications, but that does not explain why there is a drop in the foreign filing. I could make a theory for these years. Okay, Pakistani economy was not doing good, and Pakistan was in the middle of war and terror. That may be one reason. But then now we are out of it for the last 6 years, and we see that the number of applications that foreigners are filing in Pakistan has gone down, has decreased.
May I add one point, please? For these 3 years, which you have the highest number of patent applications. Actually, that was the time when we signed TRIPS agreement in 1995. So there was a provision that provision of the mailbox application, that the application will keep on filing, but they will be processed from 1st January 2005. So at that time, the applications kept on getting, and they started processing their examination from 1st January 2005. So once we started those applications, so there were most of these applications, almost all of these applications are from pharmaceutical sector. So they contain salt actually, salts and derivatives. So what our law doesn't allow actually salts and derivatives. So we ask them to divide their applications into 2 or 3 or multiple divisional applications. So by dividing those applications, one application into multiple applications, that figure.
So because
for these 3 years,
for these 3 years, these are the number increased because the same application was the divisional applications were being filed. So the majority of so this is where we talk about qualitative research, and with qualitative research, that's why we would like to have people like Dr. Sohail or those who were at the head of affairs or who were doing the examination at that time. So this also resolves the query, at least for us, that this spike that you see is not actually real innovation or inventive work. It was actually some applications that were being filed here, and because of some provision in the law, these applicants who had already filed an application somewhere here had to divide the earlier application into new applications, and that's what added to the number. But again,
Sorry. Before the 2005, the system was declaration as a substantive examination.
okay.
Before 2005, you have the substantive
Yes.
examination system as
No,
well.
always,
No declaration system.
no,
Just
always happening. Yeah, but the number of applications have actually kept on going down, and now we have around 550 applications that are being filed by non-resident companies. And we will also look at some of the data in this slide, in this presentation, for a better understanding. So, this is a ratio between applications filed by residents and non-residents. So for example, for every 100 applications filed by non-residents, foreign companies, in 2002, Pakistanis were filing around 5 applications. Okay, but we see that this ratio has gone up, and especially in the last few years. Now we see that the relationship or the ratio between non-resident and resident applications is, for every 100 non-resident applications, Pakistanis are filing 75 applications, which is creeping close to 100%. We don't want the foreign applications also to go down significantly, because foreign applications are a great source of technology transfer, even though a lot of people would disagree with the way technology is being transferred with patents. There's a huge question mark on whether patents sufficiently help in technology transfer, or they only are source for enforcing rights. Only enforcement of rights, no technology transfer, it may also happen. But the good thing is that we do see, as a ratio, that the number of Pakistani applications are increasing as compared to the foreign applications. Okay. This was supposed to be the center, but somehow it has moved on this side. This is basically the top 20 countries from where the patent applications have originated. The patent application filed in Pakistan, these are the top 20 countries where it has originated. It's one of the very important slides, I feel, in my presentation, because it gives at least the policymakers, and I don't know if there's any sitting here, an idea of which countries are interested in Pakistan as a market. Yeah, so it can give you some indication of the trade relationship with different countries. So let's go into so this is the biggest chunk in the last 20 years. The biggest chunk of filing came from the US in Pakistan in the last 20 years. Pakistan, as we have seen, recently has become active in filing within Pakistan. So we see a bigger share now, and that is followed by mostly by countries in Europe, in the European Union, including the United Kingdom. For me, it was really interesting to see outside of Europe or US, it was interesting to see China and India. Japan is one of the high filers, and also Australia and Canada. So these are few countries which file in Pakistan, which have been filing in Pakistan for the last 20 years, and this can give a good indication not only for the trade but also for example. And the interesting thing is, and I'm standing in comstech, there's no Muslim country in there. It's not that Muslim countries cannot file in Pakistan. So for example, Turkey has filed in the last 20 years around 65 applications. But then again, out of that, almost 25 applications came from the same applicant.
Data last year from all over the world.
20. No, this is again the data. The primarily data is from Pakistan. It's only Pakistani data for the last 20 years.
So Pakistan is sitting in the second place.
Yes, because in the recent years, Pakistan has actually increased the number of applications. Again, a caution is there. This data does not tell you obviously about the quality of those patents. We don't know how good those patent applications from Pakistani applicants or from foreign applicants. We don't know about the quality of the application. All we know is that the applications are being filed. We will go to the publication data
of applications.
Right now, this part is applications, only applications. So
Both resident and non-resident.
everything. So both resident and non-resident, and that's why you see Pakistan in here in this.
But you were saying that we have only 1,000 or something per year in the last slide. And even India got more applications than Pakistan. And this slide is contradicting from the last one. How the
The primary data is simple. The primary data is applications filed in Pakistan by anyone from the year 2002 to 2021. That's it. That's what we are focusing on. My comment about India is not part of the data. 85,000 applications, that's what India gets. 1.4 million, that's what China gets. 800,000 US gets. We don't have anything to do with this data. I was just making that comparison. So yeah, Iran, for example, from my data, I found only one application back in 2017. Uzbekistan, again, one application, I don't remember exactly the year. But one of the things that a key takeaway for comstech could be that, we can actually get into, I don't know, do something and increase the number of patent applications in Pakistan coming from Muslim countries.
So it's a good chunk of quantitative data.
Yes.
I just want to know the philosophy behind showing this data. What do you want to explain us by this? Just you want to tell that we are increasing a bit and we have to increase.
Yes, the idea of
the philosophy behind.
The idea of quantitative data is to show that data, and there are a lot of people here who can actually come up with their own insights from this data as well. So one of the insights that I'm sharing is that, for example, we don't see in the top 20 countries applications coming from Muslim countries. There are not many. I don't know why. And one theory could be that, which also Professor Iqbal in the morning shared, that in fact there is not much inventive activity happening. From Malaysia, I think we have around 45, as I shared in the morning, around 45 applications. Maybe there is inventive activity, but do Muslim countries consider other Muslim countries the relevant market for their invention? We have to go deeper in. So the idea of quantitative research is always to give you data, and it's always useful. And then you look at the data and you can infer, you can ask, you start asking questions by yourself. Okay, why is this happening? So when I look at the data, there's so many different questions that come into my mind. Do you have any point?
No, I think it's very useful data, and there are many questions, but I think some of those would be interesting.
And so I'll go.
This shows that Pakistan is the market of the products of these countries.
Possibly.
Yes.
Possibly.
Because
So it's
mostly
not necessarily.
pharmaceutical
Yes.
and chemical.
Possibly. Why do countries file in other countries? Why do companies file in other countries? It's a very important question when it comes to patents. So, for example, there can be two broad reasons why a country would go to another country to file a patent. One for the market, and Pakistan is a big market. So there's no doubt about that. And that's why only 1,000 applications boggles me. Pakistan is a big market, and Pakistan is not also a very poor market. Pakistan is an okay market which has a sizable middle class. Okay, why do we only get 1,000 applications every year? I have no idea. So it's a question that may be resolved by a qualitative research. Second reason why companies go to another country for filing, and will file applications is they believe that there are people who are so smart that they are going to copy the invention, and they're going to sell it to another country where there's no patent, where they have not filed a patent. And there's a very interesting case, if you remember the case of where India was sending this medicine through Rotterdam.
Actually, the answer of this question would be directly linked with when you will talk about which areas, in which areas, most of the applications are coming. And obviously, most of the application has been coming from pharmaceutical. And in pharmaceutical, so for pharmaceutical, we have to understand the dynamics of the market. Then it would explain that why it is happening.
Again, it may happen that by the end of this presentation, you will still be stuck on the question that you asked, because I'm not going to give you many answers. I'm going to pose many questions. So, and then maybe from you, I can get some insights which will add to my research and my understanding. The idea here is to show that the top 30 applicants in the last 20 years, the top 30 applicants. And as you correctly pointed out, and we correctly understand, most of these companies are life sciences companies, except for 3. So you see here, Honda, Unilever, and Nust. And maybe Nust has actually filed some applications on life sciences, molecules and stuff. But most of these applicants are life sciences, which includes both pharmaceuticals and agriculture. So that's where we categorize these two as life sciences. The interesting takeaway from this slide is that most of the top companies, even right now in the last 20 years, you don't see them here. In the last 3 years, you don't see them. The data is very sporadic in the last 3 years. Why?
Could it be because it coincided with COVID?
Very good point. I mean, I didn't have this theory in my head, but it could possibly be. It could possibly be, yes. Yes. My own theories were in the last few years, there had been consolidation in the industry itself. So maybe because of that consolidation, we do see less applicants filing, but that doesn't explain less applications being filed, for example.
Perhaps this could be tallied with global applications.
Exactly.
Has there been a decline
Yes.
worldwide? Or is it just a Pakistani?
Perfect. Yes. So my second theory would be, second theory was that there less applications being filed by pharmaceutical companies generally, and that's exactly what you pointed out. So unless we correlate this data with the general data, let's say in the US or in the EU, we will not get a good picture. But the interesting point is that we have an 80-20 rule. The data shows us that we have an 80-20 rule. Simple. 80% of patents are being filed by 20% of companies. 80% of patent applications are originating from 20% of the countries. Now, what does that tell us about policy? Any idea? What would, as a policymaker, if you understand, if you know that 20% companies filing 80% applications, there are 20 countries from where 80% of the applications are originated, what would you do as a policymaker?
We would like to expand the pie. Try to expand the pie.
You would like to expand the pie, focus on more companies, more countries. What else?
Sectors also.
Sectors, yes. What else?
We also strengthen the IP, actually the implementation part as well. Perhaps if people are wary of, applying here when they don't see that if I am applying for patent here and if I get it, will there be actually some sort of protection from legal protection, implementation? Perhaps, but that's.
We'll hold this thought, because when we'll come to the slides on grants, maybe you can make this comment again as well as connect.
One point to be, if you can go to previous slide, please. If you look at all the companies or the top companies actually, which are the So these are the foreign companies which are filing most of the patents in Pakistan. So these are all the companies which already have established business in Pakistan. They are all pharmaceutical. They are launching their products in Pakistan. They are having their products in Pakistan. So most of the patents they are from these companies actually. So the other companies we probably don't have market, don't have launched their products in Pakistan, or either they have launched but they don't have the selling over here. So they are not going to file actually. So the most of the patents are from pharmaceutical actually. Probably 70 to 80% actually from pharmaceutical sector. So with the time, I think might be possible some companies are also going out from Pakistan.
Yeah, for example, why is not any more active in
Some
Pakistan?
mergers are also there.
And why was actually one of the big filers. I mean, it's on number 3, and after 2011 you don't see. But the problem is, White is gone.
Yes,
That does not mean that they are not going to file. Right now, we see in the industry itself, in the pharmaceutical industry, a lot of patents are being filed, and then they're being licensed to local pharmaceutical industries. So the problem again with Wyatt, it's a very, I don't know, it's a very specific point. Maybe I don't know about what's happened to Wyatt in the last 10 years.
I think it explains very conveniently. The reason is the companies are no more very much interested to file pharmaceutical related and high tech related patents in Pakistan, because they know that our basic manufacturing capability in this area is almost zero. The problem is, if we want to do a reverse engineering in this particular field, we need a raw material either coming from India or China. So they are focusing on patents in India and China, so they can actually block the manufacturing and export from there. So that's why they need not to focus much on Pakistan, because if you will not be having an access to those kind of APIs, then how you will manufacture?
And if I take this comment and I connect the comment with your comment, what should be having in mind this reality, there are two possibilities that the government can do. Either to increase the capacity within Pakistan to produce APIs, for example, and the second would be, if they can't do it at least in the short run, expand the areas of interest, the fields in which applications are being filed. We correctly understood right now that most of the applications that are being filed are in life sciences. Almost, I would say, more than 80% of the applications, rather even more, that are being filed in Pakistan.
So from this, you must say that 20%, or let's say 100 companies are there who are applied for patents in Pakistan. There are 20 companies who are filing 80% of the chunk.
Yeah.
And have you jotted down or what are particular from those 80%? They are all they mostly from pharmaceutical or life sciences, you said, agricultural sciences. So in other words, you want to say that to increase this, we have to open new horizons.
Yes, and again, if we take the comment that Dr. has already mentioned, how would we, what would attract applicants to file foreign applicants, especially to file again patents in Pakistan? Again, either Pakistan is an interesting market, or Pakistan is an imitation market. And I don't want to dampen the mood. So Pakistan seems like, with this data, Pakistan seems like neither, unfortunately. And again, standing in comstech, the idea is to actually emphasize on the fact that either you become an interesting market, you get ill so many times that there's a big market.
By volume, we are a big market, but by value for them, we are
exactly. So by volume, we may be a big market, but by affordability, we may not be a big market. Second, become good copier. Make it difficult for them to ignore you. I know that's being reported, but make yourself, and that's what we discussed it yesterday. And Mitra actually discussed it in the last slide. So there's the difference between a copier and an imitator. An imitator actually learns, and actually this is how all the big economies that you see today became big and IP enforcers or IP exporters by actually having a very no rules game back in like before 50s, where they could actually imitate, copy, and then get to that level where they start innovating. So there's a trajectory that you need to go through to become innovative. There's actually data, a very interesting and a seminal paper. I think, Dr. You might have seen it by Vinarte and Park, and they have updated the data 4 times at least. The conclusions remain the same. Till a certain point in a country's GDP, it's advisable to not have a strong patent laws or IP laws. And after a certain point in the GDP, which obviously differs for different countries if you go to micro level, but at a macro level, a certain level of GDP, only after that it makes sense to have strong patent laws. And that's one of the big criticisms on the TRIPS system or the international IP system, that right now countries like Pakistan and other developing countries who are behind the race, the international IP system actually crystallizes the positions that we have as net importers and West or other advanced countries as net exporters. Having said this, there have been exceptions. So it's not that Pakistan cannot break that glass ceiling, if it can.
Sir, how can you technically differentiate between imitation and copying?
I cannot, and I'm not even going to try. What we agreed last night on definition, and that was Dr. Iqbal's definition, you were there, sir. So his point, and I take it very well. So he said that you copy and you do not improve, you do not learn, and that's where you are copying. And if you imitate, you are there too. So you imitate and you learn how to do it better, and at some point you do it innovatively. So that's
you put some your own way.
Your own way, exactly. So you're not in trademark law we call it slavish imitation. That's actually a term in trademark law, that you imitate somebody slavishly. Don't have a relevant term in patent law, but I would say that.
Technology transfer, is it imitation or copying?
Again, if you are not improving yourself, it's copying, and if you are, it's imitation. But countries have actually leapfrogged. Now, the problem with Pakistan in terms of, or similar countries in terms of policy today, is that the level of international regulations that we have to comply as a country are so much. There's a professor, I forgot his name, he actually calls it the spaghetti bowl, or the spaghetti bowl of international law. And when we look at international law, I'm not a scientist, so I have more of an international law background. When we look at it, we're like, yes. I wrote my PhD on FTA, free trade agreements, and I wrote a chapter for like 40 pages. And when I read it, I slept. I fell asleep. I'm like, nobody is going to read it, nobody is going to understand it. And I had to convert it into numbers so that I could actually make it interesting. So the international legal system is very complex, and in many cases, if you don't have good, let's say, officers or lawyers in your country, you will make a disaster in making policies and laws. This is the second stage after application, examination and everything. Let's say everything went well, and the patent office actually issues you the letter or notice of acceptance, and after the notice of acceptance has been given to you, the application is published. Now, publication is not a small event. This means that the patent office and controllers like Dr. Sohail, they feel that your application is patentable. Okay. The only barrier between publication and grant is that the patent office actually wants the public to come forward and identify if there's something which may destroy the novelty or the inventive step or whatever the requirements. Okay. So publications, except for this fact, publications are as good as grant. Okay, so when we look at publications data, what we are trying to see is what kind of applications were actually being filed in the country, whether they were patentable or not, whether they were inventive or not in the first place. So a lot of applications are being filed in Pakistan. Many of them are just, they're not even worth the piece of paper they're printed on, but a lot of applications have actual inventive worth. We are going to disregard this part because the general principle is the closer you are in history, the less examined, the less applications have been examined. So this does not give.
Sorry, sir. From application, we mean request for a formal request for getting patent. And publication means that
Examination is done. So you apply, then there's an examination. The examiners do it inside the patent office. They send you examination report and objections or whatever. You respond to them. And then if they are satisfied that yes, your response is correct, or you amend your specification, then they publish. Okay, so make it very simple. You don't get a patent at this point because after that Pakistan has an opposition period in which third parties can actually come and oppose your application. If they don't, if your public application does not get opposed, it's the publication is as good as a grant.
How much time is required for that period, sir? When they publish that thing?
So there are different time periods. I'll come to data on This is an interesting slide. I'll come to this. I'll try to go as fast as I can. Publications. So this is.
Do they grant a specific period for opposition?
Yes, 4 months. 4 months. Yes. You cannot, and it's a hard period. There's a case law. There's case law.
So that means the difference between green line and blue line are the rejected applications?
Good, very good question. Not necessarily. One of the problems in Pakistan is that there's no time limit for applying. So thank you for bringing this up. I was about to give this theory. So one interesting part is that you see that the publication numbers are almost similar in this area. I think that this is more representative of the number of publications because in these years now, in 2022, I don't think that the patent office will be examining these applications. So the number of publications are now we are pretty sure that this number will not change. So this number actually shows you that only these around 300 applications filed in a specific year were worthy of giving up.
Getting published.
Yeah. So they're worthy of being called an image. Now, what is wrong with these? This data does not show us anything. And then we come up with either we go into qualitative research or we come up with theories and we test it. One of the theories that a part of this has been rejected. Okay, one theory. Second would be a part of this was examined, the report sent to the applicants, they didn't reply. And it's pending. And that's the problem with the law right now, that it does not have an upper limit. Yes, there is no upper limit for filing a response. That's bad. That should not happen. Third point was very interesting. One more point. So before the grant, you actually get a letter from the IP office that you should pay the sealing fee. And once you pay the sealing fee, you get the grant. So a lot of applications get published, do not get opposed, get the letter from the patent office for the sealing fee, and they don't pay a sealing fee, and they are still shown as publications.
They are not granted.
They are not granted because sealing fee, and that's a very administrative thing. You just pay, I don't know, 6,000 rupees, 6,750, and you get the grant. So you have come all the way to the tail of the elephant, but somehow you're not making that jump. Yeah.
Sir, I have a question. Focusing on the applications
that are filed by the foreign countries, foreign applicants. This means that those foreign applicants have actually applied for the patent somewhere else, maybe USA or Europe, and then within a period of 9 months or 1 year, they are patenting in Pakistan. So my question is that if a Pakistani researcher wants to patent, so is it advisable to patent first in America and then in Pakistan, or we can do it both simultaneously? What do you recommend?
Okay, so I'll give you a very general answer to that.
Yes.
You can do it simultaneously. The law says, Pakistani law says that first you will file in Pakistan, wait for 6 months, 6 weeks, and then you file anywhere else you want to file.
This is the Pakistani law.
This is Pakistani law, section 25 or 26.
Why is that? I mean,
76, okay? But now you can also get an NOC kind of thing, foreign patent license or something from the IP office, and you can directly file it. I don't like it because I think that if Pakistanis are not filing in Pakistan, I'm not against it that Pakistanis directly filing in the US. I would prefer to Pakistanis to file so that their innovation appears in Pakistani data. That's one of the reasons that people.
One more reason is also there. If you study in detail those sections, actually, the logic behind that section is actually there are certain inventions which may be of some sort of strategic importance actually. So the 6 weeks per time that can be extended up to the, I think, 9 months or 1 year for them, depending upon the nature of the invention. During those times, suppose the government doesn't want to allow you to public your invention in the other countries. So that's the time period for certain strategic inventions not in general actually. One of the reasons that.
This graph shows you the ratio publication to application. So how many applications were filed by either residents or non-residents and how many were published. So again, this ratio shows you the inventiveness, let's say, of applications. You see that somehow, I don't know why, the resident applications had almost, let's say, every 100 resident applications filed, the patent office actually accepted for publication over 60. For every 100 filed, it accepted for publication over 60. So this means that the patent office thought back in 2002 that of 100 applications that Pakistanis are filing, 60 are patented, 60 are invented. And then the number goes down drastically in 2005, and then we see there's some erratic behavior somehow, which is not explained by the data right now. And then we do see the decline here. The decline in this is corresponding to the decline in the non-resident applications. I don't know why this happened. One of the theories again that this is closer to present, so less applications have been examined. But I don't think that this area, again, in this area, publications that needed to be done, examinations needed to be done, were done.
Actually, if you till 2006, there was a provision in the patent ordinance, we were bound 18 months, 20 months, 21 months in total, that we are bound to finalize the case in 21 months. So definitely within 21 months, we will have to go for publication. But after 2006, that provision has been lapsed. There is no time limit. So at both ends, at patent office and as well, and at the applicants as well, it's your option. You can linger on the case, and you are not going to submit the cases. So
sometimes I find in my data applications that were filed, and when we come to that were filed 19 years back and just got granted.
I have.
So they have less than 8 months left for exploitation.
I have personally filed the application which are still pending, and those applications are filed in 2016 and 15.
Yeah.
That's great.
The trend lines show you that generally speaking, the performance of resident applications for publication, accepted for publication, is better as compared to Pakistani applications. So more as per in terms of average ratio, the foreign applications perform better as compared to the Pakistani. But this data does not correspond properly with the grant data. This is the distribution that you're talking about in terms of the classes of the fields of technology in which patents are being filed. It's only Pakistani published applications, only Pakistani. And all these classes are either life sciences, so even from Pakistan itself, pharmaceuticals, agriculture, or chemical. No engineering, nothing like that. And this is top 10 classes. It's a partial IPC, it's not full IPC. Full IPC is, I think, 8 digits or even more. So again, we can see what kind of areas Pakistani applicants are filing, are researching. And most of the Pakistani applicants are actually from research institutions. In the grant data, I just want to show you that you will see these are the applications, total applications, and the grant has almost leveled at 15%. No, the grant data is this. So you see it inward. So from here till down. So it's 15% of the applications that are filed in a year, only 15% get granted. Now, one theory that I shared with you with regard to applicants not replying, if you compare this data with the publication data, this trend line that less, you will see that that the grant average is higher for Pakistani applicants. So at least partially, my theory about Pakistani applicants not replying, on the face of it seems that they are. On the face of it. I don't know, so it has to go into more deeper appreciation of the data. But we see that the grant numbers have also declined in the last few years. I personally like this slide very much because this slide shows you effective patent life. Effective patent life means how many years are left after the grant. Okay, so you file on, let's say, day 1, you get granted in year 3, and you have 17 years to actually enforce your patent. In Pakistan, under the law, you cannot enforce the patent unless it's granted. You don't have the rights. So that's what we call effective patent life, which means that the number of years or days or months left after the grant till the 20-year period. The interesting data is that chunk of the applications that were granted had 11 or more years or 10 or more years left for exploitation, and the big chunk is on this side. What does this mean? This means that at least we can question the argument that Pakistani Patent Office is not working. We can actually challenge that assumption. We see that chunk of the applications have more than 10 years left, which means that for majority of the applications, examination, patent office took less than 10 years. And if you go even here, it's even going down. So one of the things that we always hear from different people, that one of the primary reasons is that Pakistani Patent Office is not working. At least with this data, I can start questioning that assumption. So not everything is bad in the data of the paper.
So is it, we see almost 800 applications and 17 years left, or it was granted after 17 years?
No, 17 years left. The 17 years are left in all these applications. You have 17 years in which you can enforce your application. So you have 18 years to enforce it. There are some applications which were filed in the same year as what somehow I don't know what happened, what kind of magic did they have to make that happen.
But sir, normally I understood that after the grant of the patent, you have 20 years, but the
No,
way
from the date of filing.
from the data filing only. So it's all over the
And
world.
that's why a lot of countries cry, or different countries, that you take so much time to actually examine, because the rights should start from the data filing.
Why does it take such a long time to file the application and draft?
I have no, okay, I know, but I'm not. It's not easy. It's not just Pakistan. It's in pharmaceutical industry, 5 to 7 years is the norm. It's not
If you
unusual.
look at the data worldwide of change, so if you go to the official website of UK IPO, so they have given that the average grant time over there is 5 years, more than 5 years. So most of the patent offices worldwide, they are taking 4 to 5 years, 6 years. Even Japan, they will go to 7 or 8 years. Now they are trying to decrease the grant period.
I think in the coming years it will decrease because of two factors and both technology. One will be AI. Okay. And I don't want to predict a doom to a patent procedural system, but with the NFTs coming in and coupled with AI and blockchain, we may not need examiners that much. It may happen that AI will be able to do all the examination that you need to be done. Only the some part of that examination will be required by the examiner, and obviously you will not have the need to actually go to the patent office in the first place. You could actually simply get an NFT on the invention. Again, the examination system is important, and we will not be able to go away completely. May I? Okay.
No, I just want to say mention that in AI technologies and technologies like that, it's going to be kind of infrastructure technology to the other fields, because artificial intelligence and that sort of technology is going to be in health sector, to vehicle system, everywhere. It's not an independent.
Okay, and I love this slide because
I have a different point actually. I can understand long period for 80,000 applications in a year. I do not understand why does it take such a long time if there are only 80 applications in a year.
No, they are actually 900.
900, okay, 980,000 is
I totally agree, but you also have to understand.
6 examiners.
Again, I mean, there's so many things that
There
I
are
want to say
examiners.
and I try and not say them because somehow I don't know how to say things politely. So, unfortunately, the IP administration system, I don't say it needs an overhaul, but it needs a lot of human resource. When people leave, we don't get new people. And again, for a good examiner, we need easily 3 to 4 years to actually get to a point where they can do a decent examination. And in the Pakistani Patent Office, an examiner is supposed to do examination in all fields. The biomedical graduate is supposed to examine engineering applications as well. So, this is somehow.
They are field specific, but definitely if you don't have
You get
that specific,
of course, you will get the applications through. And that's because the human resources are there. This is an interesting slide because I want to know, okay, so you see most of the Pakistani applications coming from these 3 cities, Karachi, Lahore, Islamabad. Okay. How many of you are here from Sialkot, Rawalpindi, Faisalabad, Peshawar, Multan, Hyderabad, Jamshedpur, Mirpur, other Kashmir? Anyone from Faisalabad? Okay, so we are all from Karachi, Islamabad, and Lahore. Cool. So that explains why we don't get application from the cities. No, I don't think so. But this has a very important policy application. What's happening in those cities with those institutions? Why are they not filing? Is the audit not good? Is the research institutions are not good? Are the professors moving to these big cities because there is more opportunity in these cities? The livability in these cities are better. So any good researcher would like to move to Karachi or Islamabad. So there may be some reasons that are external to the patent system itself or the research R&D system. So I don't know. I mean, Dr. maybe you can convey this slide to somebody who can do something about it. Closing. Patents are actually a social contract, as Mitra pointed out, between the society and the inventors. And the social contract is very simple. You give us disclosure, add to the stock of the knowledge of the society. We'll give you exclusive rights, which you will be able to enforce through different enforcement institutions. Now, this quid pro quo was very interesting when the knowledge was not global. So even today, when somebody does not file in Pakistan, the researcher can actually go on patents.google.com, SpaceNet, free patents, and actually get the knowledge because the knowledge is available online. So my point here is that yes, it's good to have many patents in the Pakistani system because then we can actually say, okay, fine, we are also as good as I don't know, some Western country. But is that the goal? The goal is to actually patents still remain a tool for exclusivity, which means that a patent holder, other things remaining constant, can actually exclude. I can exclude all of you as a society, as a member of society, from using my invention if I don't want to. Simple. So there is a huge cost that the society incurs by giving out patents. At the same time, a country like Pakistan, which does not get a lot of patents and still does not use the information that is available globally, it's a huge cause of concern, especially with regard to the researchers. So a lot of researchers can simply go on these different databases, learn what's happening, what's new. They can obviously sort the data by year or something like that. So the idea here is we should not be overwhelmed by the less number of patents being filed in Pakistan. Especially when the information is available globally, the knowledge is available globally, you can actually access that sitting at your home. It's good to have patents if it is increasing the innovative capability of a country. It's good to have that. I mean, I should not say it out loud. Okay, I'll rephrase. It's always good to have that system because that's what most of the people would like to hear. But practically speaking, you have to look at the conditions of your country, and then you advocate for a strong patent system, a normal patent system, or a weak patent system. Yeah, this is what I meant. This is the conclusion that I have. So thank you very much. And now,
Yes, sir. Thank you very much. I think this was very useful, and because we all carry the kind of perceptions about the IP system or a patent system, and evidence-based statements are generally lacking in our society, and you know very well. So this is quite good. Towards the end, I actually want to ask you: have you ever worked on this aspect as well? Because having patents and granted patents is per se not the objective. Because, and especially with regard to the resident patents, once they are granted, what is actually happening? Yes, this is a huge question because just granting patent and filing patents by the residents, if it is becoming a kind of the patent rituals, because HSC has a lot of focus, because we are so much interested in the rankings and there are numbers, so which is also a sort of purpose, but the broader purpose is something else. So with regard to the resident patents, especially I'm interested to know if at all there is some kind of data, some kind of track record, and what is actually happening over there. For
there is a possibility to actually get the data from the patent office because the law actually requires to register your licenses, and it also requires to register your assignments. So that's by law required. That data is not public. I know from anecdotally, I know that NUST actually does a lot. So I got the information that NUST actually in the last few years they licensed around 40 patent applications. Dr. Saab is sitting here, Dr. Saab is sitting here. So they also license to the industry. They actually, HEG has a very actively collaborating with some industry partners, and there it's happening. But yes, the number of applications is high. You look at the number of grants to actually come to that point. And the number of grants, they only, in the last 20 years, I think for Pakistan, special applications, I think only 400 grants out of, I don't exactly remember the total number of Pakistani applications in the last 20 years, but the grants were only 400, which is like not even 5% of the total applications, even less. And then we don't know the quality of those. One of the problems maybe with regard to application and grant, that HEC, I don't know, HEC requires you to put in the in your so show how many patents you have, or you only show the number of applications. I'm not sure about that. So maybe
Both are there.
Both are there.
KPI, patent filing has separate numbers and approved patent has separate numbers of the KPIs.
But we do see the impact of the HEC policy of actually requiring the researchers to show patents and both applications and grants. If there are no other any questions that
So having more patents, does it clearly mean that research is improving in that country and commercializing and the economy is growing? Is it the indicator or there's something else?
Yeah, so very good question. It's not the short indicator of innovation. Okay. Patent data is indicator of patent activity. Okay. Even though a lot of times, obviously, patent data is considered to be one of the most important indicator of innovative activity, simply because this data is quantitatively available. So it's easier for us to look at something and say 1, 2, 3, 4, 5, 10, 5%.
But we don't know the
It's
quality.
easier for conversation.
Okay.
And I'm not saying that it's not an indicator of innovative activity at all. Okay. It is, but you have to extrapolate the patent data with, I don't know, some other data, GDP or collaborations or projects won. Licensing.
My earlier question, a part of which as ma'am already explained, but I want to get it precisely in Pakistani scenario. For instance, practical example is a researcher of my university working on, let's say, aloe vera juice, and he get it patent from. The time she or he files the application, is it as she, and then basically she wants to get it published as well as a research article. Can they get it published in after just filing the application, or just they have to wait for the publication of that? You said that the publication of that patent.
No, they can publish. If they just want to publish, they can publish.
You just have to file the application, and then, and how much time does it take to get file an application for a patent in Pakistan?
I wouldn't try and answer that question because it will not be a right answer. So it depends on the field, it depends on who is writing it. For example, he'll write fast.
If you are talking about just filing,
Drafting.
filing is a different thing and drafting is a different. Drafting may take a long time, but filing you can file with one section. You just need a pay order and you have prepared a document, just to submit at the patent office.
Any question on
for preparing the document?
It again as it depends.
It's not easy to answer this
Yes.
question in a number.
It depends upon the complexity of the inventions, output from the inventor, and the capability of the person who is drafting the application.
If you have any questions with regard to this or relevant, but more relevant to that, because the next,
So, as somebody can say, if in a short format, the patents which are licensable are actually the patents. That can actually happen.
yes, that's what Dr. Saab also mentioned, that you get the licensing data and you understand what is the worth of a patent. Like because and then forgetting. So at some point, sometimes, and especially in the US, for example, where the technology market is very active and the technology competition cutthroat, you don't license because you want to keep that patent with you and attack anybody else who is coming into the market with new innovations. So actually sometimes, and that's why a lot of us who study innovation economics, we say more patents do not mean more innovation. And sometimes you take out patents to stifle innovation rather than encourage innovation because you're actually telling your competitor, no, you can't do that. I'm already there, or halfway there. I've already have the patent. We should not work in that area. So this is the kind of, we call it patent fencing. There are different names. So yes, licensing data can give you a good idea of the. Good. So I think that is it. Yeah, there are no questions. I don't know if Leila is online already.
Yes,
she is, and she's waiting, and I cannibalize her time because my time. Okay, that's not going to come into the case. So thank you very much, and I hope that these slides gave you some clarity and posed questions that were interesting, gave you this marathon of your brain, why is happening like this, like that. If you have any questions, please feel free to write to me. I don't know whether it's still shared. My last slide had my details. Thank you very much. I think we have this session till another session till 1:40, 1:45, 1:30, 1:45. Yes, 1:45. So, are you going to ask Leila to start? I just don't see.
She's correct. We have to be on the first two. Is it okay? You hear me?
Noted. Mute. Okay. Then I can still share my file. What did you say? Because I'm noticing. No.
They are not connected. Okay. I just want to confirm. बात को समझ आई? बन गई? हाँ। कोई मसला है तो मुझे बता दो भी लाइन पे मैं बता दूँ. Ma'am, they got your ID. Okay. Ma'am, please share your screen.
Share what? It is. Oh yeah. It is. Yeah, I can now. I can do it now.
Hope you have opened your file also, the presentation file.
Okay. Oh, Paul. Yeah. Let me. Yeah. Let me a second. I will show you the screen. Yeah. I share the screen. Okay. Okay, you can't. I can't upload it. Okay, so I must enter into this, and you can see my share screen, yeah. Let's see. I think it's not. I think it is not here.
There is an option of screen sharing. Okay, when you click on that, the file must be open in your system. Then the screen of that file will be shared. Okay.
Okay.
And then you will be able to present in front of all the participants. Yeah, am I right, sir?
Okay, I am trying.
You have to use the share the screen.
Yeah.
Click on it and the file will be then shared.
The files is in my is my desktop, but I can see desktop, my desktop. Basics, PowerPoint. Oh yeah, maybe it's better to file.
Please talk with our IT person.
Yeah. Hello, I'm here. Yeah. Laptop.
There is an option of screen share. You can see it on the bottom when you open your Zoom session. It will be on the bottom or on the top. There are many other options like chat and participant lists and more.
Let's go back again.
Can you share the mic and camera?
Let's.
You can enable and disable it.
I don't know why.
First of all, let me do from start. Are you connected to the Zoom session? Can you see other participants which are connected to Zoom?
Yeah, I can see.
Okay. Now move your mouse left or right up or down so that press escape button. Simply press escape button on your laptop.
This one?
Escape, ESC, the most.
Yeah. Escape. Yeah. I pressed it, but it is still here.
If it doesn't work, then you just click on the screen and move your mouse left, right, something.
Oh, so it
will be an option of your mic where from where you can turn on and off your mic, your camera.
Yeah, there is a mic. My mic is working. The second one is camera. Yeah.
And the third one?
Yeah, the third one is the I don't know. Log meeting.
I think just move your mouse. The third option, and it will tell you what it is. I think it will be CSP. If you just click on this.
I clicked on. Lock meeting, enable waiting room, hide profile picture, something like that. Allow participant to share a screen or something. I can do it from my screen. I can share my screen, you know, comstack. So do you have my screen? Do you see my screen?
Let me connect to the Zoom session. I am now connected to the Zoom session. I connected. I can see something.
Yeah. That is exactly. Okay. So I will, you know, I will continue with my sharing screen, and my PowerPoint has been shared to everybody. Yeah. Okay. Is it okay? But I can see, unfortunately, the camera and also the chat box. Is it okay? It's now. Okay, good. Okay, good. Thank you. Thank you. I can't see your, you know, your interaction. I just see my presentation, and I hope it works. So if you have, I don't know if there is any problem or something how I could see it. Anyway, I would start in 1 minute. Is it okay for all you? Do you see? Oh, here it. Participant there chat.
Yes, it is okay.
Oh, there's right. Okay. Okay, so I can have a chat box here. I can see the chat box here, and then if you, okay, good. I hope this works. Okay. Hello, everyone. Salam alaikum. I hope you all are good. And do you have my voice?
Yes.
It is difficult to.
वो माइक ऑफ तो नहीं है जो कॉलर माइक था माइक ऑन है लेकिन वो काफी दूर है उसकी
Okay, good.
Please start.
Okay, good. I hope you all are doing well. Thanks, Comstech, giving me this opportunity to be there virtually. Today, I will discuss about patent portfolio management. I'm a little bit late because of troubling connections, and I hope I could present my presentation in time. So, yeah. I am Leila Zarei. I have MS in environmental. What is that? I have MSc in environmental engineering from Wageningen University in the Netherlands, and also LLM in intellectual property from Turin University, WIPE scholarship. I was, and in the Netherlands, I was a NAFIC scholarship. I have over 13 years experience in IP right, mostly focused on patent. I've worked in various fields, including IP management, patent drafting, patent searching, patent mapping and analyzing. At the moment, I work as consultant and lecturer in Iran Vice Presidency in Science and Technology in Canon IP, and as well as Iran National Fine. I also have my own firm working on patent-related, providing patent-related services and consultancy. I also had, before entering into intellectual property, I had over 6 years experience in water and wastewater industry. Okay, so what we talk about today is a patent portfolio management. We start what is patent portfolio. We discuss about patent portfolio, the definition of patent portfolio, what are the benefits of patent portfolio, is the patent portfolio make sense only for large companies, how startups and small companies could make patent portfolio. We discuss about this especially. We focus more on this, how we could generate our patent portfolio and how could we manage our patent portfolio. But the first question is, what is a patent portfolio? We are going to going to discuss about patent portfolio management. But before that, we must have a definition of a patent portfolio. A patent portfolio is a collection of patents owned by a single entity, such as individual or corporation. The patent may be related or unrelated. Do you have my face as well? Let's start chats. I turn on camera.
Yes. See.
So I don't know. Okay. Good. So this is the definition of a patent portfolio, a simple definition of a patent portfolio. We say that the patents in the patent portfolio may be related or unrelated. What does that mean? I always look at my, my table to find something to show this. For example, I work in most manufacturing company, and I have a patent portfolio for most products. However, my patent portfolio, my patent portfolio has several collection of patents. Some of my patents related to these scroll wheels. Some of them relates to, for example, to optical sensors. Some of them relating to the function of these buttons that enable me to connect to the computer or a monitor or see that. I have also some other patents, several patents relating to, this is wireless most. I have also several patents related to those short wavelength radio communication patents. These all are in my patent portfolio. Some of them exactly related to my products, this patent, these modes. But some of them, for example, those relating to short wavelength radio communication, maybe 2 or 3 of them are used in my MOS. Some of them are used in another devices. They cannot be used in only MOS. They have another application. The functionality is not relating only to the MOS. Therefore, I have some unrelated and related patents in my patent portfolio. Okay, so the patent portfolio, we defined the patent portfolio, but why patent portfolio is important? Actually, patent portfolio, in a patent portfolio, each patent has its effect, has its effects, and depending on supporting business strategy of a company. Therefore, there is several patents in a patent portfolio. Each of them have its own specific role in supporting business strategy of the company. And they all are underpinning, the direct sale or licensing of patents based on business model of the company. If you want to name some benefits of having patent portfolio, we can summarize in these six category. They can use to prevent or delay the introduction of competing products. They can build your brand and reputation as a top leader. It is so, especially for wants to be leader in a technology. It could be strengthen your position in business negotiation. It can be generate revenue. You can generate revenue via licensing out of the technology. You can use also patents portfolio as leverage against or lessen your competitors' power. And also you can add your company overall value by patent portfolio. Okay, so if we look at patent portfolios of big companies, big companies have big patent portfolio, large patent portfolio. What contains in their patent portfolio? There are several kind of patents. Some of them are core patents. What is core patents? Core patents are mainly covering core technology of a company, and they are so essential. They are so essential for IP strategy, for business strategy of that company. So we have core patents that cover core technology and essential achievements of that company. Another type of patents we have in portfolio, especially in those big companies' portfolio, is defensive patents. What is defensive patents? Defensive patents is those patents are filed for primary intention of defending patents against lawsuits. Therefore, they are predicting when they manage to have defensive patents, they see the future. For preventing some problems that may happen in the future, they file defensive patents. We also have patents for out-licensing. What is patents for out-licensing? You see, you remember this, my example, this mouse and several patents that related to this mouse. I told you that I have in my patent portfolio several patents that are related to radio communication. Only 2 or 3 of them have been used in my mouse. The rest are used, have been filed already, but are not used in my mouse. I can use it for out licensing. Who needs these patents? Who wants exclusivity on these patents? Then I could license it to those companies or those entities that needs such patents. There are also some emerging technology or future technology that cover uncertain application. What is uncertain application? For example, if we back again into this example, we have, we might have some patents relating to application of mouse, which is suitable for example, quantum computing. We don't have quantum computing at the moment, but we predicted this application in the future, and R&D had worked on it, and we had filed some patents relating to application and most that could be used for quantum computing. Therefore, these are not used at the moment. It is unlikely we might use for out licensing because we want to keep them for our future. And therefore, this is, future patents. This is emerging technology, and it might use in future, but there is a possibility that they never use in the future. I explain here the rule of 2080 that always mentioned it in the previous session. What is that 2080? When the number of patents, as the number of patents is increased, the number of useless patents is increased as well. What is the useless patents in the portfolio? You have 4 patents. It is not useful, useless, but there are some kind of patents. For example, these future patents, defensive patents, patents for out licensing that might not use anywhere. After a while, we cannot license them. We cannot sell them. We cannot getting value, benefit from them, and they turn into the junk patents. Junk patents, and this means that in accordance with our useful patents, we also have the junk junk patents that are those useless patents. So the big portfolio of big companies, large portfolio of big companies normally contains such useless patents besides some useful patents that can turn into revenue and can benefit them. Now we are going to explain patent portfolio benefits. We can categorize the benefits of patent portfolio into two categories, the monetary and non-monetary benefits. Monetary benefits is market monopoly position for the portfolio holder and revenue from licensing the intellectual property. And non-monetary benefits includes a strategic advantage like first mover advantage and defense against rival portfolio holders. What is first mover? You see, this is the patents have been filed in artificial intelligence in 2017, and as you see, we can see in this graph that IBM has a large amount of patents filed in this field. Some of them have been filed in PCT, some USPTO, and some China, EPO, Japan, and so on. This is, IBM wants to show itself as first mover in artificial intelligence. IBM has enough resources to file patents, then enter into this, enter into this patenting and file many patents, and therefore has got a huge patent portfolio. This is only about artificial. These patents have been filed only in artificial intelligence. Other field has other portfolios, and therefore IBM, for being first mover and for keeping monopoly position in the market, has filed many patents. The other companies follow the IBM. Patent monetization through licensing. You have heard many about this option. When you hear about patent portfolio, you may remember some things about transaction news that are talking about patent transaction between big companies. For example, here Ericsson, Digital, Nokia, Qualcomm. As we look at the income earned by this transaction, we can see the net income that they earn from this from their patent portfolio transaction is somehow much higher than net income of many developing countries. Therefore, the question may raise here that if a patent portfolio or having patent portfolio is issue of big companies or startups or in developing countries can do, can file patents for having patent portfolio, and they could benefit from their patent portfolio. It's the question that may raise your mind. Excuse me, I opened the, oh yeah. I thought maybe you have any questions because I so now we have building patent portfolio, and which is issue of without, maybe it was issue of big companies, but building patent portfolio is limited to large companies. We want to clear that this one. Patent portfolio, it depends on size of company. Do you think it depends on size of company? Some people in a startup, some innovator in a startup think that going into the building patent portfolio is useless, because patent portfolio is filing patent is time consuming, costly, and there are several problems. They need several times to enter into that process. Therefore, they prefer to don't think about patent portfolio. I always say that building a patent portfolio is like cleaning home. What that means, you know, cleaning home. We are always don't like to cleaning home. I don't myself. I don't mean myself, but for most companies, I mean that you know they think that it's hard, it's time consuming, and is uncertain, and something like that, and they want to focus their attention into building not building patent portfolio, but also instead you know, managing their product, focus on building their product, working on their business model. So why they should think about patent portfolio and building a patent portfolio? This is this seems useless at the beginning, but I always say that building a patent portfolio, filing patent anyway, not you know, for purpose of building a patent portfolio, is useful for every company, because you know, if we don't clean our home, garbage you know, a lot climb over our head, and we can't focus on our work, because there are some mess around of us, and we can't you know, mindfully think about our work. Therefore, building patent portfolio is so important, and work as a cleaning home. Why do a startup actually need to build a patent portfolio? What do you think about this question? Cleaning home was reason, but why cleaning home? Because they sometimes they need, sometimes in future they will need it. They need it because in the future might be some competitor that took advantage of them, and you know, free riding might be happens and something like that. But the reason why startups actually need to build a patent portfolio have been asked from different startups and different people, from public, and the main answer of all of them, of most of them, was to enforce it against competitors. But this is the wrong answer. Why this is the wrong answer? Because enforcing against a competitor is a good reason, to benefit, is good source of benefiting, but it is not a good reason to you know, filing patents and building a patent portfolio. Why? Because the reason that this does not make sense for a startup, it takes an enormously long time to get a patent. It depends on country by country. Differs. It differs, but you know, in some countries, in some developed countries that have big market, it may take even 4 years to get a patent. Therefore, we must take care of this patent. Another reason that that does not make sense for a startup, this reason is not make sense for a startup, it's the fact that they need an enormous cost of money to actually bring a patent infringement lawsuits. You know, bringing somebody to lawsuits is so costly. Therefore, it would not be an option. It would not be a reason that you know, small companies intend to do that. Not too many startups have that kind of cash lays around, or the particularly okay from an investor, because you know, startups normally have begin their work by an idea, and if their idea and are attractive, if their ideas are attractive from the view of investors, their investors finance on their work, but however, they are not let the startups to enter into this risky process that may cause many many disadvantage for them in the future. Therefore, what is the main reason that startups build a patent portfolio? It depends on increased value. What is increased value? Investor tendency. It depends on investor tendency. Investor tendency, patent normally works as signal, giving a signal, and having patent portfolio boost up this signal. What is the signaling of a patent? If you are an inventor and you have worked in your invention, and you are going to file your invention as a patent, then it shows that this invention has value for you, that force you to clean room and enter into this costly procedure and this time-consuming approach. Therefore, a patent could be considered as a signal, and having a patent portfolio boosts up this signal. And it is so important because having patent portfolio increase the value of startups. Another reason is they deter patent infringement lawsuits. This is so important, especially in developed country, because infringement lawsuits is so common there, and having patent portfolio, result of a survey had shown that many startups that had patent portfolio in US were not sued at all. It is, this is a good reason that startups begins with building patent portfolio, because at least they cannot be sued by other companies. And this could be a reason. Another reason that startups do actually build a patent portfolio is joint development, possible joint development agreement, and strategic partnership. Large companies normally looking for brain power, technology, IP of this much smaller company. Therefore, having patent portfolio, enlarge this opportunity, enlarge bargaining power of these companies to enter into such collaboration. Another reason that could be important for startups to have patent portfolio is increased leverage over a strategic patent by filing designer on patent portfolio. As I said, you already some of patents in a patent portfolio cover the main technology and core technology of a company, but there are several patents could be filed which cover design arounds by making this design around could prevent possible infringement in the future and possible lawsuits in the future. And so filing design around is so important for patent portfolio, and the number of patents in a patent portfolio is, as I said already, is filing design around. We also can make patent families, startup cover all possible further development in the specific field of technology and getting exclusivity. Getting exclusivity is so important for many of the startups. Therefore, building a patent portfolio help this and could help this approach. What is patent portfolio management? What we said so far was about patent portfolio definition and the benefits. But what's a patent portfolio management? What is the patent portfolio management? Patent portfolio management refers to the practices of practices that determining what to patent. It is so important what to patent, how to proceed during the patent application, drafting, and prosecution process, and how the patent is eventually used by a company. There are so important reasons, there are so important factors of patent portfolio management. Patent portfolio goals, therefore, is determining what invention should be patented. I explain in the next slide with more detail these goals. Determine how patent application should be drafted and prosecuted, and determine how patents should be used and whether they should be monetized. They are so important for patent portfolio holder to get reach these goals. What to patent? It is so what to patent. It is a question that many startups ask us in the beginning of their activity. Many startups have idea, but some of their main idea are not patentable. There are many ideas that startups are based on them, have started their work. However, such ideas are not patentable necessarily. Some of them could be patented, but some this is not true for all of them. Therefore, it is necessary to determine patentability of the idea. For determining the patentability of ideas, we should have knowledge about national and international law about patentability. Subject of invention is so important. I had some clients from startups that comes to me and ask me about, they had their main idea is a kind of platform business or transactional platform, which are not allowed to be patented because according to national law, business model or some kind of application that those platforms are formed based on them are not patentable. I had some inventors asked me about website, patenting website, and known application, recipe, diet plan, discovery, and so on. They are not patentable. We say that you should make patent portfolio, but we should take care of what idea they are going to patent. Beside the subject of invention that might be not patentable, we should take care about novelty and obviousness of those inventions that come up with the inventors and they want to patent it, because this is so important. I will discuss it in further slides with more details. When do startups and young companies need to start building their patent portfolio? This question may have, you might have answer, you might have heard that the answer of this question as early as possible. But in in practice, it depends on norm of industry. For biotech companies, for pharmaceutical companies, this is so critical to file their patent as soon as possible in any way. In any way, I explain it later, because anyway, for example, some countries have a provisional option for patenting, and this could help those companies, those industry very well. But some high-tech companies, while we recommend them file your patent as early as possible, however, there are some consideration that they can delay a little bit. What is that consideration? Startups sometimes no, not sometimes, most of the times they need funding, and some of high-tech companies funding tied quite close to intellectual property. If there is so, there's therefore patent position critical to funding early as possible. For example, as I said already, biotech company, pharmaceutical companies is of those technology. Moreover, some IT startups, some IT-related startups, for them also patent is so critical for funding, because investors, VC, want to be sure about exclusivity and returning back their finance. Therefore, for such sector, such industry sector is so critical to having patent as early as possible. But in some area of industry, it is important, but it's loosely into funding loosely to intellectual property. It means that there is a big space for for innovation, and investor not have any concern. You have more time. Another recommendation that I we always use to people in startups, in a small and medium-sized company, knowledge-based company, is whenever you could sufficiently develop an innovation, you can write it. Whenever you could write it down or explain it to somebody, what is essential element or process of it, you can file your patent invention as soon as possible. There are another, I have seen some companies, some medium-sized companies, small companies, startups that already had patents, and this makes the way easier for them, and that is so important for them. Why really filing is essential? Early filing is essential for startups, because some of what I'm saying has been said by Mitra already. First filing and priority to file is so important. It is really important, because when you want to build your your patent portfolio, you file your patent and expand it as a patent portfolio into a patent portfolio, you must take care of first filing. Most of the innovators, inventors think that they are only person that are working in a specific field, a specific industry, a specific solution. But I should say that they are not only. Remember this statistical fact that in each minute, 5 inventions are being filed. Five patent applications are being filed. Therefore, some things that comes to your mind to solve, maybe it might have, it's likely to have come to other mind, to other people's mind in other side of the world. Therefore, be careful about first filing. First filing is so critical, and you remember what I said about a cleaning room. If you, for most of the startups, as I said, a cleaning room is not, is not fun, and they prefer to focus their attention into other works that are really important for them, that they think really important for them. But there are some companies that have developed their products, they have worked on their business model, but at the end, they can't file their invention, they can't file any patent application because they have lost their priority. Somebody else in other parts of the world have filed it, so they can't get patent on it, and the ideas have lost, and the advantage, they lost their competitive advantage that come with patent filing. You must be careful also about disclosing earlier the filing patent. You know about grace period, you know about what is that grace period. I think you know about that. Because I think in Pakistan we have 12 months grace period. As I notice, yes, am I right?
No, there's no 12-month grace period.
I don't have your voice. Is it 12 months?
Yeah, so we don't have 12-month grace period. We have 12 months after provisional filing.
Oh, I unfortunately I couldn't have your voice. Anyway,
Okay. Can you hear me now? Can you hear me?
Yeah.
Okay, so we don't have a grace period provision in the law, but we do have 12 months after you file a provisional application. So you can.
Okay, so you have provisional application, but you don't have grace period.
No, we don't.
Oh, so yeah, it is important. Grace period, so you must be so careful, more careful about disclosing earlier than filing patent, because, for example, in Iran we have 6-month grace period, and people are, are relaxed to disclosing their invention to the public due to such 6 months opportunity. However, when you want to, build a patent portfolio, this 6 months, is for you. Some other countries have 12 months. For example, US has 12 months grace period. But when we want to build a patent portfolio, we might notice to our freedom to disclose in such grace period, and we didn't notice that in other country might have not grace period, any grace period. Therefore, it is so important to notice from the beginning which countries are you going to commercialize? Are you going to enter into, for example, negotiations later, commercial negotiations later, and you seek the market there, and if they have grace period or not. It is so important. You said that you have provisional patent filing. I like really provisional patent filing. It is so good idea, this option, because you can. It brings many advantages. There are several advantages provisional filing brings, and few countries have provisional system in their patent system. Why I like it, because provides you a 1 full year before officially patenting it, and during this 1 full year you will be able to legally claim the patent pending, and it's so good. And it also brings some advantage. For example, you can secure your foreign priority. You can enjoy less formal requirement, and you also can get in commercial promotion, because as soon as you file the provisional application that is written in an informal language, you have the chance to discuss, and you have the chance to talk about your invention, your innovation to somebody who could interested on it, without worrying about this disclosement might lose your priority on that invention over that invention. Therefore, provisional patent application is so a good option, but be careful about its turning into non-provisional. Many people are forgetting about its turning into non-provisional, and it causes some matters, because they think, okay, I've filed, and that's all done. But filing non-provisional patent application is so important for those countries, and don't forget the data. We also take care about first file, because patent examination determine whether your claim invention is new and non-obvious in view of technology that was known before the filing date of your patent application. Therefore, you have to first file your invention, your patent application, as soon as it comes in your mind. Then you will otherwise you might be lose the novelty and other patentability requirements regarding to novelty and inventive step. Sorry. One of building or managing patent portfolio, managing patent portfolio was determining what the invention should be patented. Trade secret to patent. Some companies, as I said you already, some companies, small companies, I mean, startups mainly, are refuse to patent in the beginning. They think that they keep their invention as a trade secret. And for most of startups, there is doubt to have trade to cover their invention by trade secret or filing a patent to protect it. What is important to making a decision about keeping invention as a trade secret or filing a patent is visibility matter. What is visibility matter? If what is visibility means? If you cannot access the goods of other people, products or services, how you could infringe you. It is so important, visibility. Some things, there are some visible matters that are obvious. They can see, for example, they can see it and do reverse engineering. Therefore, for them, it is essential to file a patent. But there are some technology, there are some innovation, invention that you have developed already, but they are less visible. And no one can understand what is behind them. Therefore, you can keep them as a trade secret. Otherwise, if you file them as a patent, after a while, after 18 months, for example, in many countries, it would be published and it would be in public, and everyone could know about that invention that was not really visible to everyone, and you could cover it by a trade secret, you could protect it but by trade secret, but you disclose it in a patent application, and therefore visibility, so it is so important to get into account the visibility matters. For this, many, as I told you already, many companies tend to keep trade secret because they don't want to enter into costly and time-consuming procedure of patenting. So they try to keep it as trade secret. But for many startups, it's being concerned because they can't keep it as a trade secret. Some employees, for example, employees are leaving, irritations sometimes happens, and information leak out. Therefore, keeping those invention as trade secret is so difficult and hard to maintain. And ability to maintain trade secret is so important. Some big companies have NDA agreements, and they are well managed NDA agreement, and they have some incentives for employees that they they could keep them, and they are therefore they are so certain about keeping the trade secret. They are so sure that they can keep the trade secret, but it's not possible for all the startups, especially because as I said, employee leaving and leaking out of information have been occurred a lot in these companies. Another reason for another part of patent portfolio management is determine how patent application should be drafted and prosecuted. It is so important. As I said, I like provisional approach. Provisional always is recommended. Buying 1 year, keeping priority is so important. In some invention, that is not, that is critical. First filing, entering into provisional application and filing a provisional application could be so helpful. Therefore, consider filing provisional application, especially in those countries that you want to enter into their patenting process. You must consider how many countries are you going to file. If you are going to file, if you see a market opportunity in more than, for example, 2 or 3 countries, is better, is recommended to file PCT application. Otherwise, if you, for example, if you see few amount of market, little market for your invention, is better to go from Paris Convention approach that makes it easier and even less costly than PCT application. PCT application, PCT means Patent Cooperation Treaty. Iran joined this PCT, this system in 2013, but according to my knowledge, Pakistan is not, is not member of PCT. It's good option for filing patent application, and I hope that Pakistan and other country join the PCT application in the next future. Some countries have divisional application, CIP. I'm not sure that there is these options occur, that Pakistan have this option or not, but many English language or some countries that were already and are following, Britain law, have divisional application or CIP. I'm not sure if Pakistan have those. This also help us, to manage better our patent portfolio. How they could help us to manage better, because you don't have to file different filing. It disclose the main idea of your invention into one application, patent application, and after a while you use, for example, CIP continuation in part, and you develop, you have worked on some part of your main invention, and you develop some innovation from that part, and then you file CIP for that, or maybe you can file CIP for some idea that comes to your mind, because it would be good to, it would be an option for you to have those invention in the future. As I said, we file some future invention in our patent portfolio, and CIP could be helpful for that. Divisional application is so important because you don't have to file another application. You only enter into divisional application system, and a part of the main application divided into next application. In this approach, divisional application and CIP, you don't lose the priority filing, and that is why it is important. You have to consider translation, patent attorney in countries that you are going to file your patents there. In some countries, translation and patent attorney, especially translation, is so high, and many inventors tries to ignore filing patent there because of high cost of translation.
Leila, can you hear me?
Yeah.
What's CIP actually? I understand the divisional application, but I'm not getting the CIP.
CIP, okay, good question. CIP's continuation is continuation in part. Continuation in part means that you have filed already a patent application that your main idea have been disclosed there, but after a while you have developed in some elements, some specific feature of that main idea. Then you can see some innovative in that in that part. You want to file you want to file CIP, but you want to file another application, but in some countries that have CIP approach, it makes it easier because you haven't lose your priority as you have filed already your main application, and you won't lose your priority over the main idea that covers the further features and the further elements. And while you having priority, you can file the new innovation that has happened after some while working on it and working on your invention, some working on development on part of that invention. Was it understandable?
Yeah, it's okay.
Okay, good. Translation, I was saying that translation and patent attorney, it's so important factors, and you should notice them. Some of countries, as I said, the cost of this are so are so high. You have to spend lots of money on them, and you have to you have to determine, is it worth to file while you have to spend lots of money in translation and patent attorney or not. Sometimes if you file your patent application in those countries, but you can get if some infringement happens in that country due to law enforcement in such countries, you can't defend of your your invention there. Therefore it's better to determine all aspects together. Maintenance fee is another issue that you have to take into consider when you managing your patent portfolio. How much you want to spend and keep your patent in different patent offices, part of the world. Sometimes for some kind of technology, for example in IT technology, there are so new technology are coming day by day, and what I have filed, for example 5 years ago, is not does not force anymore, and therefore why I should spend lots of money on maintenance those those technology, those patents that cover such technologies. You should take care and take into account maintenance fee of different countries, different jurisdiction you're going to file, and have your patent portfolio, some part of your patent portfolio there. Another Another part of patent portfolio management is determine how patents should be used and whether they should be monetized. It is also so important. Has patent you file, patent application you file, are you it's going to be your product cover all of this? This question should be answer carefully. Do you need to buy or license other patents to develop your products and to have monopoly on selling such products or not? Do you license or sell the products, the patents? Sometimes I have lots of patents. You might remember the example I said in the beginning. Most manufacturing company, it has it had lots of patents in radio communication technology, but the company doesn't use such patents in its products. It has to the company has spent lots of money, enormous money, on getting patent, but it has been useless. It has to license out or sell it to other company that might be interested on those technology. This factor should be considered in the beginning and during patent portfolio management. In the procedure, we should consider, we should take into account, we should monitor the patent or patents have been filed and make a new decision about them. We also have to careful about we should be careful about a potential licensor, potential collaborator. If we need a broker to to sell or license it, how could you monitor infringement? We sometimes we file some invention. For example, we have many inventions that has been filed in US, Europe, and so on. But how we could monitor if any infringement is occurred? Therefore, monitoring infringement is also important, and for keeping patent portfolio, for managing patent portfolio, is a monitoring is a costly way, but anyway, it is necessary to better manage the patent portfolio. So we are going to what we said already was main things about patent portfolio management. In a few next slides, I will go to explain some things about generating patent portfolio. It is practical experience, almost practical experiences. You might have have used them already. For some companies, some startups companies that are going to you, or you are going to have your startup company and want to desire to have a patent portfolio on it. It's better to write down any idea that might be patentable, that might not be patentable, but it's better to in the beginning you write any idea. Problem solution, when we this is a fact, then when we invent something, there some problems comes besides that solution, that invention. For example, if we a simple invention, a simple example I would say is, for example, in water treatment, desalination, you might have you might have developed nanofiltration. Nanofiltration is so good for desalination purpose. However, it needs, it comes to market besides some problems. Those problems are clogging by elements in the water, need requirements to a high amount of energy. We should take them into consideration. And these problems comes to this idea. So what would be solution? Could I work on that solution and write down everything? And if you could work on those solutions and solving such problems, they might be your, they might constitute your further patent portfolio. Therefore, take into account every problem, solution, idea by brainstorming comes to your mind and comes to your minds of your co-workers, colleagues, and so on. Determine which of invention could be patentable. It is so important to have a patent attorney, patent agent in your sessions, in your meetings, in your brainstorming sessions. They, for example, they could help. They could help you about, okay, you said that, but it is not patentable. It would be patentable, but I should, but I should. But I should monitor if it is novel and have inventive step, and it would be patentable. So it is better to determine which invention could be patentable to be in your patent portfolio. What proportion of invention does your budget allows the filing of patent application for? Budget is so important, so important, especially for startups that are going to develop their main idea, and they are going to develop their main products. As I said, they might not think about patenting their idea in the beginning, but if there is any option that they could patent their invention anyway. Do you have my voice? Do you have my voice? It says that my connection. Do you have my voice?
Yes, it's okay, dear Leila.
Okay. Budget, as I said, is so important. It doesn't let a startup to file whatever they want. Some of their ideas, some of their solutions, some of the problems that I told you already that can convert it to patents might not be attractive for investors, VCs that have funding on that startups. However, we should take care about, we should monitor how we could file it in less budget as much as possible. PCT, as I told you, is one option. Another option is provisional filing, but we have to take care about limitation, time limitation that provisional filing application brings to our, to our area. Therefore, budget, do whatever you want, but consider budget. And use use possible options that could save your budgets. If competitors were to copy the invention, would be easy to deter this and prove it in court. It is so important, to file a patent that it is not easy to make make design around. If some competitors copy our invention, would it be easy to detect this and prove it to the court? It depends on enforcement law of our country or other countries that are that we are willing to file our patents there. Be careful about the rules. Sometimes you spend lots of money in filing patents in some countries that don't have such enforcement potential, and it is what you have spent on filing and having patent portfolio. Some part of it, it's going to garbage because it doesn't make any benefit for you. So be careful about the enforcement rule of the country you are willing to file your patent there. But your strategy to commercialize your idea, it's you have to determine. You have to determine at the beginning what could I do with the patents, with those problems, solutions that I approach, which some of them was patentable. What could I do with those? Do you want to produce by yourself? Do you want to produce any product by yourself? Investment and financing, you should take care of investment and financing. Some investors do not feel secure to invest their money in some companies, some ideas that are that doesn't have exclusivity. So it's better to have such exclusivity to attract invest and financing and so on. Another question you have to answer is, do you want to license some or all? It depends on your budget. It depends on your business strategy or something. Would you prefer to have collaborations? It is so important because many of small startups, many small companies, after a while join with a big company, and what do they have for those big company? What do they have for those big company, and these which patents, which inventions, which innovations they have could bring the big company to the collaborator main competitive advantage and something like that to attract the collaborator and investors. I recommend, after writing down every possible solution, after writing down those questions and answering them, it's better to, you have reached to some idea. It's better to rank them. Rank every invention based on visibility, compelling the feature. What is the meaning of compelling the feature? Compelling the feature is ability to design around. Sometimes you file a patent application, but there would be many chance for other people, for competitors, to design around that. So this is a factor that could be ranked when you want to choose and invest on some inventions that you want to include in your patent portfolio. overall market impact is so important. There are several ways to determine overall market impact. You have to also do some works, for example, novelty search before filing patent, because in some countries you spend lots of money to filing patent, hiring attorney or something, but the idea is not novel. The idea is obvious. Oh, sorry. Is there any problem? I see my voice reflecting. I recommend it's better to do FTO search, market search, competitive search in order to make a better decision for proceeding the patent portfolio. Do market and competitive research based on your business goal is so important. Evaluate risk and benefit in each step. Risk and benefits in each step is, you arrange, you organize a patent portfolio, okay, but for managing your patent portfolio, you have to time check it. You have to check if some, some patents have to be removed, some ideas have to be removed, pruning have to be pruned, because it is not useful for you for being in your patent portfolio anymore. So be careful about checking and monitoring your patent portfolio time to time. I've seen some, some solutions about better managing patent portfolio regarding to specifically budget cost. We can when you manage patent portfolio, there are a lot of concern came to your mind. Globalization is one of them. Overwhelming data that you can get from the novelty search, freedom of operate search, and you have to analyze them, but you have to take care about budget. And what we can consider about budget, it's removing those wasting resource. What are the wasting resource? Normal costs as official fee, filing fee, application preparation cost, staffing and systems, for example, translation and hiring patent attorney or so on. Prosecution costs from counsel and vendors is so important, but some of costs are wasting resource. Seeking patent that will not facilitate business goals. You must take into account that filing patent must align with your business goals. Must be aligned with your business goal, and it's so important. Some patents are not following your business goal. It's better to throwing them. It's better to removing them from your patent portfolio and not spend too much money on them. Another things, unnecessary and uninformed prosecution. Sometimes uninformed prosecution happens. For example, you have filed in China, patent in China, but they have some formal requirements that you haven't predicted, and you are not looking for a market, for example, in China or Thailand or Taiwan or something, some country else. So remove such unnecessary and uninformed. It is better to be aware of such uninformed prosecution, and if you can remove those patents that cause problems for you and doesn't make sense in next 5 years or more, it's better to be removed. And another another reason, another subject that you have to keep in mind is maintaining irrelevant assets. It's so important also that you know, or as I said, everything should be aligned with your business goals. You have to ask yourself, these assets, these intellectual assets, is aligned with my you know, with my goals, business goals, or not. To how align your business goal with your patent, it's better to determine, you know, determine the business actualities. Determine business actuality. What is the meaning of business actualities? For example, you have to file. You are willing to file your patent portfolio. You have to. You're willing to have patent portfolio in many jurisdictions. In some jurisdiction, you want only to make. In some of them, you want to use or sell. In some of them, you want to have some advantage that they that filing patents there brings for you. For example, as an inventor, I prefer tax incentive for tax incentive. Which countries have tax incentives? I remember that China, Malaysia had already tax incentive that was so you know, was so good for inventor and innovator. I'm not ever you know, I'm not updated during last years, but it was already in those countries. So be careful about, you know, where I using, where do I sell, where am I, where are my top you know, revenue jurisdiction, what I need to do, and prepare a table for them. You know, it's better to writing them down, documenting them, and I say that it's better to have you know, to have all in your in a picture. It's better to write them in a table, and this table should be in your should be in front of your eyes to, you know, to make better decision, or you know, rephrasing the your patent portfolio or something like that. Determine competitive intelligence. As I said, it is so important. Some countries, you know, you can learn many things about your competitors. Competitors, what is the meaning of competitors? Who are working in your field of technology. For example, you are scientists working in a university. You are not, you don't have real competitor in the market, but who is working in that field should be can be considered as your competitor in that field. What they do and how, follow them, monitor them, and keep in mind that monitoring competitions, competitor in your field of technology brings many ideas to your mind that you could use them for making better decision. Sometimes you are blocking competitor, or you wanting to maintain some power of our competitors. They are so different meaning. If you are want to blocking competitors, you have to, you know, you have to file patents, essential core patents, as well as you know, those design around patents. Then you have to spend lots of money on them. But sometimes you have to, you want to maintain some power over competitors, which inventions, which you know, which patents in your patent portfolio could help you to reach that. Where your chief competitors are making, using, or selling, what are their top revenue jurisdiction, where are their sale office, where they have patented, and why. So this is essential to monitor your competitor. Competitor, as I defined already, is somebody who works in your you know, area, in your technology area. You must
Sorry,
take care
Leila.
about all of them.
Sorry,
Yeah?
Leila. Can we manage the time, please?
Sorry?
Can we manage the time, please?
Okay, it has finished already. You know, this is the last slide. This is the last slide that I found this you know, table interesting in one patent in one firm that was managing patent portfolio, and they divided you know, what was important for them in this category. And I was really interested in them because they divided you know, what they wanted to different jurisdiction, and ranking them and choose what, which one of you know, jurisdiction is better to file patents there. I already finished, and I hope you like it. Then I'm going to your questions.
Thank you, Leila. If there any question? No, actually. Okay. In the afternoon session, we will have the case study regarding to the patent management. I mean the intellectual property management and patent portfolio. I hope that we will have you. We'll have you online, Leila.
No, I'm not.
You are in a meeting. You are in another meeting. Oh, okay. We'll manage it. Thank you very much.
Okay. Thank you. Thank you for having me. Okay, have a good time.
Thank you, Leila. Bye for now. Okay. Dear participant, it is 20. Quarter. Bye, Leila. It is a quarter to 3.
Bye.
Is it half an hour enough for lunch? And for the afternoon session, we don't have such lectures. We are going to work on cases, and we are going to divide to different groups, okay? And to read the cases, and me, Fatima, and Dr. Owais are here to help you read the cases and give your suggestions. Is it okay? Half an hour is okay? Negotiable? See you.
It was anyway 45 minutes, so we are not asking for much. It was anyway 45 minutes, so half an hour. In Pakistani, we fast.
We have 2 cases, okay? We treat it in different ways. The first case is about a university professor. A university professor, Pakistani, who is in Emirates, and we want you to be in groups. I think you are 22 or something like that.
Not anymore. People have eaten and fallen.
Okay. You can remove. Group of 4 is okay, or group of 5? 4 or 5?
It's 3 and a half.
I think 4 is fine. 4 is.
Okay. You can share.
Yes.
Okay, and you four together. You 4 together. for other certificates, you are going to send me the file, okay? It is not an obligatory part of the course actually, but you can, I will tell you. Okay, there's a two-page instruction, the history of the case. Please read the history of the case. There are 4 questions in the challenge. Imagine you are the expert in the item management system, and you are going to give your recommendation to the university. What can they do in these 4 challenges? Okay. 15 minutes is okay for 15 minutes, I think is okay. Then there is no right and wrong answer, okay? This is just a strategy. After 15 minutes, we ask team by team here to present a solution for the challenges. And the other can participate about this solution, and we can negotiate about the cons and pros for each solution. Is it okay? So for 15 minutes. And if you need any help, Dr. Race, Miss Fatima and I are here, okay? I said we'll come to the tables. Yeah. Let them time to read.
Yeah, how do you want to share this? I've sent it to. Zoom is everybody coming?
Is it okay to share with you? I need one can add here.
Would you like to announce that the case has been shared online?
So the online participants, we share the case one in your private message. You can read the case individually and think of the 4 questions at the end of the case. We are going to discuss about the solutions. So there is no right and wrong, answer, just there is solution and strategy. Imagine that you are the consultant, IP consultant. You are going to give recommendation to the university. Thank you. Maybe the project. Some collaboration. Some of them.
So we have 5 more minutes. Five more minutes to conclude.
We can give them 7 or 8.
I'll give them 7 or 8, but I should tell them. Pakistani sir.
روزنامه رو چیز کنم مثلا راجع به این لیست همه گروه ها بیان 5 دقیقه حرف بزنه بعد آره یه ذره طولانی شده البته واسه همین گفتم که اصلا اونو مدلش رو آسون‌تر بگیرید Unit have, we are ready, we're done. So we wait for other groups. Draw activity. Oh yeah, it's like a that's good.
We still have 2 groups working, so maybe a few minutes. Do they need to come here? Do they need to come here and or you can
Do you need more time? Because
okay, let's discuss. The issues were, in my opinion, pretty straightforward, and a lot was discussed by Dr. Kassar in our presentation. So what we do is we start with any group that would like to volunteer. Okay, that group is volunteering. Or they can, if they want, they can speak from there. They can have.
because the other maybe cannot see them. Okay. Whatever you're okay. You want to cover that?
Okay, so, excuse me, please. So this group will discuss first what they think is the solution, and then we move group by group.
Okay, just at first, please summary of the case. I want to know that, did you get the case or not?
Yes.
Paul get the case?
That's a good summary, the word yes.
The word is.
That summarizes everything.
Summarize everything. The case is clear, okay? It's a very easy case. Okay.
Yes, the first case is on the IP management, case 1. So we have gone, our group has gone through this, and there are some questions.
I think they can't hear you.
The first question is whether the university is the owner of the invention or Professor Ahmed Bakar based on the information that we have been provided. In our opinion, university is the owner because in the absence of facilities provided to Professor Bakar, Abu Bakar, what's his name?
Bakar.
He cannot develop the invention. So it is we cannot prove this in the court also that he can without using facilities of the university he cannot develop invention. So in that case ownership is university's owner and he is just inventor because he has developed his invention using the facilities of the university and because there was no IP policy of that university. So in the absence of IP policy, I think this matter should be the absence of IP policy of that university. I think country law will be used to check whether who is ownership. But according to law in Pakistan, since the university and organization where the research is going on, that university will have the ownership if some invention or some invention is made by some researchers.
Okay, just keep.
The second one is
No, that's not second. But we are going to do the first question through all the teams. And my question is that Mr. Bakar is originally from Pakistan, but now the case is in Emirates, not in Pakistan. Please pay attention to this one. And also, what about that before he came to this university, he was in UK, in other university, working in the same field, okay? Can we say that, okay, it is his own field, just thinking about it, okay, not say yes and no. It is his own field and there isn't any, I mean, the idea from the university or maybe financial support by the university, think about this issue as well. Your comment about the first question finished? Is there any objection to them? Or any comments?
I would like to say that in simple terms, we can say that he is the inventor and the university is the owner. But the point is that he's already said that he has done research on 2 or 3 patents earlier on this related topic. And secondly, we can say we know that university has not created any policy of its own regarding this, and they have not undergone any contact with each other as well. So in this scenario, we cannot 100% say that he is the university is the 100% owner. It might mean to say that they need to get into the contract as well. So that ownership and would be shared
between university
yes,
and Dr. Bakar based on the contract. What kind of contract? I mean, ownership sharing?
I mean to say that earlier university did not have any intellectual property right policy of its own, and they did not made any contract with him when he appointed the university appointed that person regarding this issue. So then now he has invented this thing. So they need to although he's inventor, but for the ownership they need he has although used the equipment and all those things, but he need to get the first of all, if there's any law in the country regarding this, that is another thing. But if there's no law and if the university neither has any policy, because if the university has a policy, we can say that when we appoint any person, we write on that all laws made by the university, you have to follow that. So then automatically
come under that university policy. So then through that university may become the owner of that.
I want to add something.
I just let them finish because I want to ask a question.
So now this both have the rights of ownership. So it would be decided, but they're gonna do.
So you believe that even if the university don't have IP policy and they have to obey the national IP rules, okay? And which law? Pakistan law or UAE? UAE.
In which they are in UAE, they are in UAE.
They are industrial.
Where the university is situated. in
From
which
where
country?
he has got the patent. That country.
From where they have.
They are going.
That country. Not where the university.
Yes.
Okay.
Yes, I agree with this. And you said that because he was working in UK and worked with many patents in UK, but if we look into the second paragraph, you can see that the idea of developing this innovation actually came from the same university in UAE, because his student actually rather alerted him that there is a problem with people facing with the handheld devices, so we need to actually develop something for this. So I think the idea also came from the university. It was not his own idea that he brought from UK, rather it was the idea that actually came into the mind from UAE, and then he used all the resources in UAE. So I think the university is the owner. In general, the university seems to be the owner, and Mr. Prof. Muhammad seems to be the inventor.
Can I ask a question?
Yes.
The idea comes from university, or the idea comes from that student? And the other question, if the second case, the idea comes from the student, is the idea from the student is in course of his or her thesis, or apart from thesis?
I think he was working on the same.
I will, sorry, add
Okay.
one thing that the problem statement came from the student. And
But
the idea
yes,
was the part of
the solution actually came from the professor.
Yes.
Okay, we have many ideas, and you said in your presentation that we cannot patent these ideas. But once we have something in hand that is something tangible or intangible, but we have a product that we can go through the patent process. So idea was there, but you know that idea, as you said earlier in the presentation, that we cannot patentize the idea. We must have something to get the patent.
Yes.
So I think the answer is
So you believe that the ownership is for university?
If I belong to the university, I will definitely keep the ownership, because everything has been utilized and in the university, and the university has paid him for his time. So definitely the ownership belongs to the university.
And okay,
if for example, like in the last question, or second last question, if they want to sell it to some company, this idea, I think that before selling the patent to some company, being the university head, I will definitely settle the case with Prof first, and then I will proceed for the selling of that invention. Otherwise, definitely I will not go into the litigation.
Let's collect all the answers. Let's collect all the answers.
Yeah, I'm writing. Okay, what's your opinion? You have to add, because I think you want to add something.
The thing is, in our group, we all have two different aspects.
It's okay, it's okay.
The thing is, if I was Professor Walker, then I will take the ownership. And then if I was the part of the university, then
It depends on your position.
so that's like the
If you were at the salon.
If you were at the salon.
The salon should directly contact the professor also.
And if you were the president of Pakistan, bring Bakr to the Pakistan.
then there would be a whole thing break back. So after, would you like to want to say?
Yes, I just, because she has a question, just a question.
Yeah, please.
If the patent is granted, then after the grant of patent, ownership can be transferred.
Exactly, like a house.
Okay. As far as the first question is concerned, whether the university is the owner of the invention of Professor Ahmed Bakr based on his knowledge and that you have been provided with, yes, university is the owner, provided the fact that the time, paid time of the professor, the resources, the overheads, the labs, equipment, electricity, everything that used of the university, therefore, university is the owner of it. But since we already have read that there is multiple communication and there is a deadlock. So at that stage, and university doesn't also have the active policy. Therefore, university needs to get into negotiation with the inventor, that would so-called inventor at this stage, and bargain on the position and interest rates. Here, the Professor Bakr has strong position. He is holding a position that he won't let go. He is the owner of thing, but in fact, he isn't. Whenever he would file a case to patent office, university can easily go and claim that the resources and everything has been used of the university, the time of the university, so the patent would not be granted. But to get out of this deadlock, I think university should offer a deal keeping the interest of the professor. That yes, there should he may be declared as inventor and on profit sharing basis. Whenever the license of the patent is granted to third party, in this case, there would be a profit sharing formula which he agreed upon, and therefore the student and the inventor and everybody involved in it would have their due share. Number one. Number two.
And then we are
okay.
speaking well. Dr. Shafi, you have other comments, yes or no? Because you are in a real position in your university to deal with such cases, maybe.
I think the first thing to look at is the UAE Patent Act, if there is a provision related to the employee intention. So if there is no such provision in the act, then I think there is open for dispute. So in this case, Professor Ahmad Bakr as an inventor has the right to file by his own to the patent office without the university become the owner, unless if there is a specific policy or the contract, employment contract between the professor and the university that states that all the inventions by the staff should be owned by the university.
And let's think about the field of the activities of Dr. Bakr, because he is working in the field of information technology. We talked in the morning session about the significant use of the university resources. Okay, field by field is different. Maybe in some fields we need more, device and equipment, material, and different fields maybe have different situations. Okay, there is no right and wrong answer. I just want to say.
The interesting part in this, and I always thought when I read the patent law in Pakistan, it says when an employee in the field of the employer. Now that's true. Think of a university.
Yeah.
There's no field of employer in the university. So university is in the field of education. It has departments which are actually working in engineering, biomedical, telecommunication, aerospace, whatever. And now you start thinking about the law, and I'm specifically about, and this language can be found in different laws. So you have this language in the field of activity of the employer. If the employee does this, then this provision applies. Now, in the case of university, what would you say? What's the field of activity? Just because the department is researching, for example, in engineering or aerospace, is that enough to make this a field of the activity of the university?
Yes.
No.
Creation of knowledge.
I'm not sure.
Creation of knowledge is the prime, you see.
But the field.
But
of
not defined
activity, it really depends on how you actually define what is activity. And usually when you think about an employer-employee relationship or a business, you know that for a fact, this business is active in this field of activity. This business is active in this field of activity. A university is actually creating knowledge, which may be the activity of knowledge creation. And then you will start telling me, okay, I created an LMS solution.
Yes.
That may be the field of activity of the university, a learning management system, because I'm helping teach. So it's not something that I'm just adding to this whole conversation. It's not too relevant for the whole thing, but obviously for a practical work, it is relevant to actually see whether there's this field of activity of the employer or not, especially if you're employed by a specialized research institution. A specialized research institution will have this possibility of having field of activity.
Okay.
This patent was filed in UAE, then as per IP policy. If there is no policy of the institute or university like that, then state will be applicable. As per IP policy of UAE, the university shall be sole owner of all intellectual property created through the use of university resources or facilities hosted directly or indirectly by fund administered by the university, developed within the scope of employment by employer, agreed in writing to be specifically commenced work or assigned in the writing of the university. It clearly states it is the ownership of the university as per UAE IP law.
Oh, you went to you solved the issues of once and for all. You don't ask them the question. He does not agree with the law. So that's not about agreeing. I just.
I think about Pakistan.
Sorry.
No, it says over here it's 2013. So was this there in 2013?
This was effective date 1st September 2014.
I should be a practice square one. I should remain
13.
No, it's
After this they started.
No, he's saying that there's a backdate application of.
I can check the previous file.
No. Okay, we will still would like to hear from them and them. So, yeah.
Okay, the next group.
I will have a question for you.
First we'll have the.
Okay, so I would like to base on you have written over here that the information provided over here. So I take the information. This only says that the university doesn't have a specialized IP department, intellectual property management. So I take it in that case, university may not have a specialized IP department, but it may have a employment contract as well. It may have certain provisions in their statute as well regarding university. There may be a national law which gives certain guidance regarding the ownership of the university, but nothing has mentioned over here. So I will assume that there is the national law. There is nothing such kind of in the national law. There is no employment contract. There is no IP policy. In that case, the ownership of is on university cannot. Because whenever a dispute arises,
I didn't get your last sentence.
Sorry,
Professor, according to Professor Bhatia,
the owner.
Because he's the inventor.
Because of.
University don't have any policy, IP policy,
because university can arise dispute only in that case if there is certain provision or certain law which allows the university to raise a dispute. If there is no law available, there is no policy, there is no statute, there is no contract, then definitely university doesn't have the right dispute the matter. So in that case, the ownership goes to definitely the industry should contact the inventor post.
And we have to think about that. Who makes the decision, the final decision? If there is a case, university is the authority who is going to take the decision, or the court.
Actually, the court will decide, but definitely if there is no national law, there is a universal law. Some common law which is prevailing through the world. Of course, the inventor is the owner of the invention. patent right goes to the inventor, and in most of the cases, if you take the personal law as well, it also gives right to the inventor that. But there are certain provisions that if in the absence of any contract, in the absence of any employment obligations, those are there, then university can rise dispute and you can go. Otherwise, the university goes to the university.
Okay, any other idea?
Well, I have a scenario, and on based on that scenario, I would like to seek the opinion. The scenario is a faculty member working in a university. He thinks of an idea that is workable. So, but he doesn't want university to be included as the ownership, and he already knows the IP policy of the university. So, what he does is that he creates a company, for example, seeks funding, gets some funds, and does work in his free time, get the results done, and then he seeks the patent on his company name, which is his own company. So what do you think? Is it legal way or illegal or ethical, unethical? So that's what I would like to.
Legal and ethical. These are two.
Yes, both.
Yeah.
So what do you think about?
What do you think the others? What the other things?
If he is using the university lab.
No, he is
for
not
his
using
startup.
because he has the idea. He is not using the.
He doesn't need any equipment. And
No. Well, that's what I said, that
First,
he
has
makes a
to like-
company, he seeks funding, gets funding, does work in his free time, and not
Yes,
using the
then
university.
he's done using any facility of the
Yeah, then he can use
In other case, he doesn't have to have funds and establish his own lab.
Yes.
He just go to university
Yeah.
or make an agreement with them, contract research agreement. That his company will do the contract research in their lab, use their equipment and IP presses with them. So in this case, there is
But
another.
in Pakistani scenario, I don't think that the university will allow him to make a
No,
company.
universities
or-
allow,
They do allow.
yeah, business incubation centers.
But
they
are
have
they
this
private or the university is part of the business?
Private.
Federal
Contract research.
Federal university allows the formation of company. It is the other universities now.
What about HG?
According to the IP policy by CCPS, it is allowed.
It is allowed.
And pay attention to that, knowledge is something accumulative.
Sorry?
Accumulative thing. Knowledge is not like this asset I buy simultaneously, okay? Knowledge accumulate during the time and during the interaction. Some of my knowledge is my own, and some part of my knowledge, I gather this knowledge by interacting to my colleague at university, and the total situation of the university give this knowledge to me, and pay attention. Any other idea? And Dr. Sahel mentioned to a very good point. At the beginning of his answer, he said that based on the information on the case, it is important. You cannot say something, you just imagine, just guess. You have to say based on the information here, if even if there is some misinformation, okay? Okay, somebody wants to talk?
Yeah.
Okay.
Based on the information based over here, when I look at this fourth paragraph, it says, Khalifa University became aware and requested him. So they actually request, if it's, they must have some legal, jurisdiction, they wouldn't have to request it. They would actually be like suing him or grabbing him that you broke the law and all. It says requested him to assign all that. So that's more like a moral or ethical thing, do something which is morally right. So I think at that point in time, and as a friend said that in 2014 when they made the law. So in the 2013 context, that belongs to the inventor. It's just a moral thing which the university is trying to impress on that inventor. Of 2014, as our friend enlightened us, then the rules came in. After that, it becomes university. It's a thing about time.
Yeah, following this comment, Imagine that Dr. Barker worked on a technology, okay, and finished and he file a patent. Now the Etisalat come to the university and ask for a joint research, not just buying the licensing or buying technology. And it means that Dr. Barker is going to have to go to work, the continue of the project, okay? Is in this case, university can oblige Dr. Barker to do something? Maybe he accept, but he doesn't accept to continue the research. In this field, the negotiation is very important. I want just to draw back your attention to this point that if there is no IP policy, every cases go through the negotiation. And in this negotiation, mostly because it is intangible asset, it is here, it's not kind of extractable, okay? In this kind of negotiation, the researchers somehow have the bargaining power, and he can force to do something. And if he don't want to do something, she said that, okay, I'm a university lecturer, just I'm responsible for a student teaching.
No, you do something else. You disclose it. You just disclose it.
Disclose. Yeah, disclose.
You have filed the application already.
Don't do that. It's not
No, for the
selection.
continue.
I'm just saying that that's the stick you have.
Just really
Yeah.
my suggestion. What happens if you, let's say, if you get the point that you disclose it? Is that some sort of a violation?
It could be. So
Yeah.
that's what I'm saying. Don't do what I'm saying.
Being intentional.
But yeah, if you're angry and if you have come to the point of disclosing, you don't care about the consequences. You're like, anyway, I'm leaving. I'm going back to Pakistan.
And now it's very funny. Your instructor telling you, your instructor in the training telling you, this is what I'm telling you, but
In Persian we have a proverb. We say that he or she didn't eat, for example, that food, and even don't give to others, doesn't give to others, and make it like make it like rubbish and give to the dog. Not eat himself, not to give the others, make it like rubbish and give to the dog.
But I've come across some cases where researchers did disclose not because of this reason, but other reasons too. But yeah, and a lot of companies actually disclose their invention so that not other companies cannot get
Yeah,
it.
that's a strategy.
Yeah,
by
it
the
is
way.
strategy, a defensive strategy.
Technology competition, actually they do that.
Yeah.
They disclose parts of their technology, which are easily.
Exactly.
Especially in software. So
Yeah, exactly.
Because it's a fast-growing technology, sometimes it doesn't worth it to go through all those patent procedures. So it's worth it to just disclose everything and just enjoy copyright.
Yeah, exactly. As Dr. Oresan, Ms. Fatima said that if maybe they prosecute for patent protection and they negotiate with examiner, go on back, and if they didn't get the patent, they publish it very soon. In that case, others, I mean, they have right to. It's a kind of public domain information. Okay, is there any?
It will be for the betterment of the public as well. They may get benefit from it. Every common person, everybody can get benefit from it.
No.
And he has or at least copyright. He has the ownership of that. He has the owner of that research. He has written a research article in that.
Yeah,
not in commercial sense, but in research sense.
Copyright has different rights than industrial property rights. So in that way, justice is copyright, the moral right. I mean, not the economic. Okay, shall we go? Shall we go to 413? Okay.
So what is the answer?
There is
no right answer.
There is no right answer.
Given the facts, there's no right answer.
There is no right. It is
But
just.
there are some people who actually go to the law actually.
It depends on.
I can give you the answer. He used to negotiate with the university. Otherwise, he has to come back to Pakistan. He wanted a job. He went busy. So, so he has to negotiate. So be practical.
It's a kind of management is the art, you know. If there is a, for example, IP office, technology transfer office, it is the wisdom of that people, even the wisdom of the researcher, the wisdom of the university, how they, the things that the lawyer do. What is the lawyer doing? Maybe you won a case, but he faced the same case. How to use and how to interpret the case, okay? If there is IP policy, okay, there is rule, and they did something. Even in that cases, in some universities there is IP policy, but somehow they, pass the policy, and because it is somehow technical field, and the university official system cannot oblige the researcher to do something. But IP policy can solve a lot of problems very easily. But in the case there is no policy, it depends on the case, and they have to negotiate. And in this case, we also can think of also free royalty. If university wants to continue the collaboration with their researchers, because it is a lot come to university to start a project. Maybe the project is now, for example, X dollar, but for the next 2 years, 10 years, it is 100X dollar, okay? They want to continue the project, so they have to negotiate to each other in that case, and the researcher must be, the university must be somehow flexible about this case to get that. And in that case, maybe some universities accept to free royalty, non-excludable cases. They let the inventor have the ownership, but the university can benefit from that specific invention, free royalty, non-excludable licensing as well. Okay. Shall we go to the second question? There is no comment?
Yes, next one.
Okay, second question.
Okay, the second question is whether PhD student who was working with professor is a co-owner of the invention.
What do you think about this, student?
In this case, the idea was originated from the student, but the solution was provided by the professor. Here it is not mentioned that whether the solution was part of the thesis of the student or not. If it is part of the student thesis, then he has done the studies, so he is the co-owner. And if not, he only helped the professor, so the ownership rests with the professor.
Okay.
If I can just interject for a very small time. Mohammed Ismail, who is director of at the IPO, has joined us, and he actually looks after GIs, genetic resources, traditional knowledge, FS folklore. So this is, and he's one of the very learned individuals in Pakistan that we have on the policy level. So and he's an old friend. We wanted to also have a taste of what we're doing here. Absolutely, come and please.
He's the head of everything here.
He's the head of everything. Yes.
Really, my great honor. I'm thinking about whatever I'm thinking about, it happens. Just I'm thinking about if we can go to the IP office in Pakistan or not and see somebody from there.
Yeah.
Yeah, exactly. Is it possible? Is it possible? Yeah, it happens right now. It's okay. Okay.
So the answer is if the student is involved in the inventive step of the invention, then he is the co-owner.
The co-owner. The next step.
This is the question is like very open and you said no right or wrong. But I'll go for that. The student is the co-owner because according to the facts of this sheet, he actually helped him for that invention. So definitely he is the co-owner.
It's a co-owner. And just and you know the word student may deceive us.
Yeah.
Sorry, may I say something?
Yeah.
A student that was working with him drive his attention towards that issue. He had told him this is the issue. And then professor worked on that issue and he invented something, and after that invention, he helped him in practically using them, finalizing them in user-friendly way.
Yeah.
That invention was done. He just helped him in implementing that. So I don't think that student is the co-author or co-owner in this issue.
Co-author.
Co-owner is not the co-owner in this because if you liked.
So you're saying the student was only an operator, like that, right?
Kind of
Co-inventor.
Co-inventor is inventor. Inventor is inventor. We don't have co-inventor.
Okay.
Inventor is the person who contributes in the conception of the idea that they claim in the claims. This is the description of an inventor. So if we are a team, but we have different patents. So we have done a project and we have 2 patents, each comprise a set of claims. It doesn't mean that our names should be on both of these patents. You know, I may have contributed in the conception of the idea of the first patent, but not the other one. So I'm not allowed to be in the inventor list of that patent. This description is very important, especially for professors when they want to decide to put the name of their students as the inventor list.
And a student can be inventor and cannot be owner as well.
Yeah.
It is not
Even if I have been I don't know, somebody just hanging around there, and then you have seen me, I have helped you, I have given you an idea which has helped you, and you have used my idea. I haven't done anything. It wasn't an idea, but you put it in the work and it worked, and the result has been good. If you use my idea and you claim it in your patent, you must put my name there. I can claim it. If I can prove it to the court.
Would that be a co-inventor in this case?
Yeah,
Or co-owner?
it's exactly this term, conception of the idea.
Okay.
Yeah.
Okay, the next, do you have any different idea from your team?
I already told you, yes.
Yeah.
You know, have a lot of consensus in our team. We have a very big team, but to me, he is a co-inventor, definitely, because as you stated that he just put some ideas. So he's a co-inventor.
Up to here, all of you are agree that the student is co-inventor.
Yes, he is not co-inventor.
Co-inventor. Okay,
He is not co-inventor.
he's not. Why?
Not co-owner.
What is your reason? Co-owner. I mean, we are talking about co-owner.
He just, you know, that it was just his idea and he just helped him in testing and finalizing the idea, but the invention actually came from him, and actually it is the mutual agreement between the student and the professor that whether he will share the ownership or not. And since the professor filed the patent, so the patent belongs to him. If students has some problem with him, then definitely that is a dispute. But if student doesn't claim it, that actually the invention goes to the professor.
Okay, any other idea? Your team.
Yeah, we agree with that. We agree all.
Co-owner.
We are actually when we are seeing the annual buffer is not in honor, then how can we see the student can go?
You think?
We are not giving.
You think
it's not?
you think that the owner of the whole invention is university?
Definitely.
Before deciding this question, first we have to decide whether the university is the owner or the professor is the owner. If professor is the owner, then the student can claim that I am also the co-owner. But the professor is the owner. But in case if university is the owner, then
Yeah, exactly.
Otherwise, student cannot be limited to know.
Good logic.
We are not talking about, we're talking about owner.
Owner.
Yeah.
Oh, not inventor. Owner is only university, sorry. Owner is only university.
University.
Yes.
Because you are from university. You're all from. And you are just I mean the researcher, or you have the management position at university.
I think they do. That's
Yes, I have 3 pages. I own name for the manager and both sides.
So you're on both sides.
Okay.
Because as university manager, I won't let the freedom office not get freedom of that. I will put in a lot of videos.
And sometimes the issues don't go such in direct way and very easy. You cannot manage. You have to manage. You have to negotiate, and somehow university obliged to be more flexible.
Before I get the first part, industry, I had to get into negotiation on interest base, watching the interest of the Dr. Bakr, and helping him to lead his strong position that he.
Yeah. Because innovation or any technology development don't develop in the isolation system.
Yes.
The system is people is inside the system. Okay. And the point here in this case is the student. Maybe they did in this case deceive us. A student, if it is the part of his thesis, and if there is IP policy, and a student maybe his thesis is something else, and he contribute in a project with the professor or his own advisor or even the other advisor, in that case, we don't see him as a student. He is a kind of researcher at university.
Yes.
And in the IP policy, Dr. Shatter, in your IP policy, you have different provision for students and researchers. Okay. Okay. In that case, we have to define that. Is it thesis or the other researchers like the research? Okay. Shall we go to the third one?
Yeah.
Okay.
May I add something?
Yeah, for sure.
I will just disagree with this.
Can you?
Yeah. Okay. Here, the student is only pointing out the problem, not the solution. As Bhakta is saying, the conceptual idea. He is not giving any conceptual idea. He is just pointing out a problem and asking the professor his attention, draw his attention for that problem. The professor is providing actually the solution. So here, this information doesn't say that the student has contributed to the research. He is working just as an assistant. So assistant means the document says that he has tested his invention. So by just assisting in testing the invention which has already been made, I assume that he has not been involved in any research. So in that case, I think he is not the owner. That's my opinion.
Yes. There are some comments there. Can you read them? And also, I want to add something about the students. I forgot. Exactly the comment agreeing for you, the lodge on the university. I think somehow. So the university is
Though
private.
the university is private enough, is private in government sector, we used to happen within the given rules and regulation of our organization. So organization in this case is owner, those scientists do invention. They did work in university and both be the author, but if he completed his work elsewhere, he will be sole author. But the PhD student is also co-author in the said case. Okay, and according to IP, who submit article or patent first, he will be the owner.
Yes.
Okay. So, okay, should I go on or you want to
Okay.
discuss it?
No, no.
Again, yes, scholarship goes to both university and professor, both must be benefited. And structural collaborative. So that's it.
And what is your recommendation in such cases? For example, imagine it is not the thesis of that student. It is just a kind of suggestion by that students to the professor, or even vice versa. The professor suggests to students. Is there any solution? Just think about it. And Dr. Sohail said that the student just gives the challenge and the professor gives the solution. In solution, we said that if you define the question in a proper way, it is the 50% of the answer. Okay.
Research problem, the definition of research problem is very important in research, in research.
Yes. So yeah, it maybe can be kind of hypothesis. They are
it's sometimes part of the solution.
Part of the solution.
Then he will be the part of study. That student will be.
Yeah.
Like you go out.
It is part of.
And yeah, if consider this, I'm talking about what you said. If this is part of thesis, we shouldn't think about it similar to the case of an operator in an R&D of a company. So we shouldn't say that, okay, he or she was he was only an operator.
No, if let's say first PhD thesis is working on that and this is, then he was the first author of that.
Not just author, but inventor is, because yeah, this is.
If you are working on PhD thesis, student is the in fact the owner and the author.
Yeah.
Teacher also is has the same second author or the author or almost have similar rights as the students as a student because he is working under his school, but main author is in fact then the student.
Yeah, and a question, except Dr. Sohail, I know that he knows the answer. And is there first author, second, first inventor, second inventor?
No, they have equal rights.
Yeah.
Because some researchers think that in the final, document, patent document, it is very important that whose name is first.
Yeah. Okay. It's not like writing an article. It is
It's
different
not.
thing.
It's completely
They all have
different.
equal rights or whatever they define in their agreements.
Do you in Pakistan define percentages like shares, like 30%, 50%?
Ownership is different from inventorship.
Because for example, in US, there is no, defining the shares like 30%.
Then what?
Patent office, there is no defined share.
They should have an agreement on the royalties.
In that case, can they say that I have 100% work and I have 30%?
Yeah, of course.
The other has 70% work, depending on they have 30%,
Yes.
70%
This is,
share or the ownership of that.
yeah, exactly. This is exactly, again, based on the conception of the idea. How much of the idea is mine and how much is yours?
Okay, and just as, quick,
recommendation if there is no IP policy at university or any organization you work, because somehow passing the IP policy is not in the hand of the sole researcher.
Yeah.
But I do recommend that write something, even with your student, write something,
Yeah.
even in email. Okay, it is enforceable.
Yeah.
Let's say there's something like that, you have 20% or 10% right in that.
Yes, writing them through agreements. If, for example, in
Depending on the
Pakistan, you define the shares, even for the inventorship, you should define it, you should write it with your students.
Share would be for inventorship as well, once you said.
In inventorship, we don't have percentage and share. Inventor is
No,
inventor.
I thought maybe they have this in Pakistan.
No, I don't think so.
You don't? So it's okay.
For inventorship, we don't have percentage. Yeah. Okay, we can go to the third one. What kind of agreements the university need to enter into if it decides to work with Etisalat? What kind of agreement university? For example, we accept that Dr. Bakr assigned the right to the university finally, or maybe he didn't accept. Okay, we have two different scenarios, because in that way university can make an agreement as well. For example, Dr. Bakr is owner and the university make an agreement for the continuation of the project. What kind of agreement do you think this is good? For example, assignment, license, if license, what kind of license?
License is the thing that.
Okay, there are different kind of license is a general term. Okay.
License is the case for the granted patent already defined intellectual property. But when they want future work relationship, then there comes the contract research agreement or memorandum of understanding defining the intellectual property rights of the future results or future intellectual property that is developed after the contract is.
And the MOU was.
MOU. You know, MOU don't have any financial burden. MOU is a kind of agreement that show that okay, we are friends. We say that okay, we are going to do something together. Okay, but it is not enforceable. Because it don't have time, it don't have money and any kind of commitment. Okay, the second group. Is there any idea or the others?
Yes, we think the university should grant exclusive license.
For the existing patent.
This patent. Yes.
But they are going to work, more on R&D.
Profit something exclusive license. So first, since they have expressed their intention to develop it further, so they would have monopoly and reason to invest, develop it further, because they would be an exclusive player in the market to market that solution. Number two, university will get an agreement with the Salat featuring Dr. Abu Bakr, Muhammad Bakr, as consultant for the technology to be developed over future course of time.
Exactly.
So the university would get into agreement.
The consultancy agreement.
Secondly, to watch the interest of Dr. Bakr as consultant, he would make the Salat agree to hire him.
Okay, what do you think about the exclusive and non-exclusive agreement? Which one is better for universities? Non-exclusive. Okay.
In this case, as development is needed and further development is being.
But if it's a Salat don't accept and say that because we pay for R&D, it is not the finished work, because they have one finished work patented, and they are going to do R&D. It means that it is a lot bring money in early stage, that there is this valley, and it is very risky.
Yeah.
You know, it is a lot pay money for nothing.
There's no product yet.
No product, no technology, and if maybe they fail. Okay, in that case, it is a lot. Most I probably like to have a more exclusive right.
Yes.
Yeah. Okay.
Depending on, I think it depends on negotiation as well, because here, the first thing I will start with the NDA between university and Salah. And then secondly, we're going to enter the licensing agreement. And then during that negotiation, we will decide whether to be exclusive or non-exclusive. And then we will state the licensing fee and the royalties. And then Salah also has the interest to work for the future research and development, and we will enter into another agreement, R&D agreement, and also consultancy agreement to appoint Prof. Abu Bakar as a consultant for the company. And in that agreement also, we have to state the IP sharing agreement between Salah and for the program IP. As a result of the new R&D with Salah and
Exactly. They are going to marry each other. It is not kind of boyfriend girlfriend matter. They are not going to be together for a short time, because they are going to co-develop a technology. In that course they have to match together very well, because in buying and selling it happens in one time. Okay, and everything finished. But
they need each other and
they need each other. Okay, the next thing, do you have any more comments to add? No comments. And there is no Dr. Sohail, the representative.
Yeah.
Okay, is there any more comments to add? Then the next one.
Done.
It's okay.
Everything university.
Okay.
We are also keeping that.
I know, just kidding.
Giving him the funding. Yeah.
And I'll the second D point when we will start discussing. Last question.
Last question. We're going to discuss about the last.
The Salah cannot make a contract with the professor because he is the individual body, and university must be there. And professor cannot make money without the contract. Patent doesn't give you money. So anyways, the university must be there and the agreement must be there, so that the university can be in benefit, the Salah can be in benefit, and the professor can be.
But do you think that there is no limitation for Etisalat? If the university said that to Dr. Bakr, I am the owner, and Dr. Bakr said no, okay, in that case, Etisalat easily go to the researcher, and this agreement is much more easier for the Etisalat than the making contract with university. Okay. And because of that, in this case, we say that university have to show more flexibility, and the fault is that they don't have IP policy. Advise Khalifa University on how manage best their IP rights in the future that are created within these premises.
First of all, we advise them to have a proper department for this, that they will deal with this kind of issues, and then they proper have their intellectual property right policy as well.
Policy.
Yeah. Proper documented thing, and then first these two things are basic things. Then
yes, we have IP policy, separate office for that matter, to handle that stuff. Second, to include faculty members, researchers, research students, and visiting faculty all together.
Exactly.
One aspect as well as.
Because there are different scenarios. They have to define that in different scenarios what's the decision.
Yes, they should consider all of them as potential inventors, whatever they would invent. Number two. Number three, they should develop a formula for profit sharing, once a license is granted to third party, that's exclusive, inclusive, whatever that is, that would be, you should have a formula for sharing of the
Revenue sharing.
revenue. So, yeah.
Revenue sharing is one of the most important articles. There are some important articles in the IP policy. Ownership in different scenarios, revenue sharing is very important, and the scope of the protection. And what do you think of, is there any other comment? Okay, IP policy is good. As I told you in the morning session, it's a kind of top-down approach. What can the university do in the down-top approach? Awareness. Maybe there is IP policy, but by mistaken or by, I mean, the unintentionally, somebody do something. And before starting the project, I mean, IP awareness means any kind of learning. It is not the meaning that there would be some, I mean, workshop like this. Okay, workshop is good, but different way of learning. In the case of, I mean, the course of starting their position, even this student or researcher or any administrative staff, they should give them, I mean, they warn them about the IP policy. Then they have, I mean, educational course about the intellectual property. You want to add something?
Yes, so I just want to add this, like what my university is doing right now is just they just have to create some competitions, like students would know if their project has the early potential to grow. So in my opinion, the university should raise the awareness campaign when it comes to the competition, so that the projects come forward and they can just see if there is early potential in that. The student on its own doesn't know if there's like any early potential or patent potential in what they are.
Okay.
Disclosure of this invention and the completion. There will be disclosure.
As we have discussed, when the department, separate department is created for this purpose, that will sensitize all the faculty members and students, and that would be the approach from bottom to top. And they will tell them that they can make seminars, they can go to them and talk to them individually. What are your interests, and what they can, they have their discussions with the industry. They can invite people from the university and get them discussion with them. What are the proper areas where they're interested in, when industry is interested to get them work on, because we have brains, we have researchers, and industry has the money. And what are the areas where they want them to work on? So if a department is properly created, then they can sensitize and they work on this, and then actual.
So yeah, I just wanted to add one point. So just like I'm from NAST, they actually organize this type of events, and some projects like final year projects or some sort of that projects that have been funded by the university. So they already come into jurisdiction of that university. So if there's no like any of the competition, I don't think so that they're going to get IP filed in ICT. So that's something that creates the IP filing opportunity for the university as well. And there are some agreements just like for the mutual partnership, where even the inventor also gets some of the view share for that process. So I believe that the competition involvement should be encouraged in this.
But here I want your comment that for patent, you avoid public disclosure, but in a competition, you are showing your invention to public.
I will tell you one point, but I think you want to add something, yes? And the point, the guy. You want to add something?
Yeah, I wanted to, from a management and administrative perspective, first, IP disclosure, IP of any sort, may it copyright, may it be know-how, may it be some
any kind,
whatever, IP of any sort. It's disclosure done. That's a 6 years after creation or after discovery, whatever. Second, at Spirit University, we have developed SOPs. We have developed procedures and procedures clearly outlined
and forms
on the website. everybody can see, and we have designated a point of contact. Anybody working on anything, stumbles on any invention, wants to have an IP, need to come to that point of contact. As simple as that.
Yeah.
And thereafter, there is IP support and other value proposition that UC has to offer. This is how we manage the IP. This is how we govern our policy from top to bottom, and the other way around from bottom.
Yes, the point is that IP policy is good, education is necessary, but there must be some kind of templates. Because sometimes researchers don't know how to negotiate and how to get to an agreement together. There must be some forms like disclosure forms or agreements or NDA templates that it helps the researchers to negotiate and fill in that forms. We cannot say that there is a unified form for everything, but it is helpful. Okay, they can change some parts. And just think something for tomorrow. If, for example, there is a kind of collaboration, like this case between the university and the industry, like in Etisalat, or even university collaboration. Each firm, each university have its own IP policy. Okay, and if there is any conflict between this IP policy, who should make the final decision about this? Okay, I think you are all tired now.
Yeah.
Just let me give you. There's a second. Okay, second case. Okay, just please read the case individually, or if you can share your ideas together. I know that you are now tired, but tomorrow it is easy. There is no question. Okay, it is a story. It is the story of a business. Okay, just read the story and find out the strategy this business used to develop its business in his own country and in the other countries, and what strategies, what kind of collaboration, and so on. Okay, just read the case. It is the story of a company, okay, of a technology. Okay, and just extract the strategy they use as much as you can. Okay, IP strategy, IP management strategy they use for commercialization and utilization of their technology. Okay, are you ready for a selfie together? Yes. Are you ready? Here. You are still okay.